We are good to go now.
All right, here we are. It's still Monday, April 5th, and we're gonna try again with our live stream going. Welcome to the Joint Standing Committee on the Environment and Natural Resources. We're assembled electronically today to hear public testimony on 5 different bills. We're gonna go in this order: LD 743, LD 780, LD 960, LD 802, and LD 872. And the chat feature will just be used for anything related to logistics, but we'll keep substantive conversation out of the chat space. And as you get moved into the space to offer your public testimony today, it might feel like you're getting dropped off, but you will reappear with us here in the Zoom space as one of the panelists, and we look forward to hearing your testimony. So let's get started with some introductions, and we'll start with Representative Bell first.
Good morning, Art Bell, House District 47, which comprises Yarmouth, Shabeek, and Long Island.
Great, and Representative Ziegler.
I'm Representative Paige Ziegler from District 96, which is in Waldo County. It consists of the 7 towns of Belmont, Liberty, Lincolnville, Montville, Morrow, Palermo, and Searsmont.
Representative Dudera.
Good morning, everybody. I'm Vicki Dudera. I represent House District 94, the towns of Camden, Rockport, and the island of Islesboro.
Representative Johansson.
Good morning. Chris Johansson, House District 145, the 18 organized towns between Bridgewater and Sherman.
And Representative Bloom.
Good morning, Representative Lydia Bloom. I represent the people of York in House District 3.
Representative O'Connor.
Good morning. I am Beth O'Connor. I represent the individuals of House District 5, which is Berwick and North Berwick Park.
Representative Hanley.
Good morning. I'm Jeff Hanley. I represent District 87, which is Pittston, Alno, Westcasset, and Randolph.
And Senator Bennett.
Good morning. I'm Rick Bennett. I serve 13 towns in the beautiful Western Maine foothills and lakes region of Oxford and Cumberland counties.
And Representative Tucker, my co-chair.
Representative Tucker, House District 50, Brunswick. Thank you.
And I'm Senator Stacey Brenner. I represent Senate District 30, which is most of Scarborough, all of Gorham, and part of Buxton. And we are also joined by Dan Tartikoff, our OPLA analyst, and Sabrina Carey, who's our clerk. And we are grateful, as always, for their support. And I believe we're going to get started by bringing in Representative Fay. And the first 3 bills we're going to hear will be introduced by her. And we'll go ahead and bring her in and get started.
I have to say that was my first experience jumping from the waiting room to the meeting. And it is, I understand why people get a little bit freaked out by it. So thank you very much, Senator Brenner, Representative Tucker. I am State Representative Jessica Fay. And are we doing 743 first? I think I caught the order.
Yeah, the hope is to go ahead and do 743 first.
Okay, great. So I just wanted to say thank you for the opportunity, and am very happy to share part of the best part of the state of Maine, bordering on Senator Bennett's district here in the Lakes region. I'm Jessica Fay, and I represent the people of House District 66, which is parts of the towns of Casco, Poland, and Raymond. And I just want to say also that it's really wonderful to be back here with my old colleagues on the Environment and Natural Resources Committee. I served here for 2 terms and thoroughly enjoyed myself every minute. I am introducing 3 bills on behalf of the Department of Environmental Protection this morning. The first one is LD 743, which is an act to amend the laws governing invasive aquatic species. I understand that the department is working with stakeholders and have requested that the committee vote ought not to pass so that they can go back to the drawing board. But I did want to take this opportunity to remind you of the importance of mitigating and eradicating aquatic invasive species, not just for our environment and ecosystems, but also for our economy. For example, invasive milfoil forms dense mats on the surface of the water, making it unappealing for recreation, harming native plants and fish, and causing decreases in property values. We need lots of tools in our toolbox to address this threat. With increased usage of our precious freshwater resources, there is increased opportunity for new infestations and for spread of existing infestations. And I'm glad the committee will be having this discussion about the issues whenever that happens. Thank you for your time, and I'm happy to answer any questions.
Yes, Senator Bennett.
Thank you. Representative Fay, thanks very much for your interest in this. As we all know who live in the Lakes region, this is a really huge issue for us. And I really applaud the department and you personally and the rest of the legislative delegation for staying on this. There's a lot to do here, and it's a moving target, and we got to stay vigilant. So thank you.
You're welcome.
Any additional questions for Representative Fay? Yes, Representative Hanley.
Yes, thank you, Madam Chair. Representative Fay, so the department wants this bill to die as soon as possible, and they have something else in mind. Is that what you're saying?
That's my understanding. I think those questions would be best directed to them, and they'll let you know what their plans are and how they hope to move forward.
Thank you.
You're welcome.
All right. So whomever is here from the department that would like to speak specifically about 743, if you could raise your hand and we'll bring you into the space. There's a handful of you, so I'm just not sure which one. Brian Kavanaugh. So we'll bring Mr. Kavanaugh in. Good morning and welcome.
Good morning. Can you hear me okay?
We can, yes.
Great, thank you. Senator Brenner, Representative Tucker, members of the committee. I'm Brian Kavanaugh. I'm the director for the Bureau of Water Quality at the Department of Environmental Protection, and I'm speaking in opposition of LD 743. The department administers a multifaceted invasive aquatic species program that includes prevention, early detection, and control. This bill was introduced at the request of the department to strengthen various aspects of the program by expanding the list of invasive plants, that's section 1 of the bill, and by removing a requirement that specifies that chemical control agents, herbicides, may not be used on a water body that is a public water supply to control invasive plants without the prior written consent of each public water supplier using that water body. That's section 2 of the bill. Over the last 2 months, the department and staff from the Department of Health and Human Services Drinking Water Program have had discussions with various public water suppliers and their representatives that have voiced opposition with section 2 of the bill as it is drafted. I expect you may hear from some of them this morning. We agreed in concept that there may be alternative language that would be acceptable to all parties. However, additional outreach and discussions would be needed with the additional parties before revised language could be suggested. We realize that it is not possible to do this outreach within the timeframe of the current legislative session. Therefore, we are respectfully requesting that the bill in its entirety be voted ought not to pass. The department will then continue to work with the drinking water program and the public water suppliers to craft a bill for a future session that we hope will have broad support. I'd be happy to answer any questions you have now or at the work session. Thank you.
Thank you, Mr. Kavanaugh. Are there any questions for Mr. Kavanaugh? All right, so what I would suggest is that we close our public hearing on LD 743 and we move into a work session for LD 743 and then make a motion ought not to pass. So I'm gonna, yes, Representative Hanley.
So moved.
All right, so now let's go ahead and open up a work session on LD 743. Yes, Representative Hanley.
I make a motion we ought not to pass on this legislation.
Do I have a second?
Second.
Great, lots of seconds. And then do we need to do a roll call on this one or can we just do a show of hands? Yes, Dan, Mr. Tartikoff.
Sorry, I might have missed it since you went so fast. Was there a vote taken on going to work session?
Yes.
Okay.
Maybe not. No, there was a motion to go to work session, but I don't think we voted on it. Do we need to go back 2 steps and vote on going into a work session?
I didn't hear any objections, so I'd assume the vote was had.
Okay. All right. So now we have a motion on the floor, ought not to pass with a second. And we need a roll call or can we do a show of hands? Representative Tucker?
In the past, we've started the practice of taking roll calls on bills. And since this would dispose of the bill, I think we probably should do a roll call.
All right, a roll call it is.
All right. LD 743, the motion is ought not to pass. Senator Brenner.
Yes.
Representative Tucker.
Yes.
Senator Bennett.
Yes.
Representative Hanley.
Yes.
Senator Carney. Absent. Representative Bell.
Yes.
Representative Bloom.
Yes.
Representative Dudera.
Yes.
Representative Gramlich. Absent. Representative Johansson.
Yes.
Representative O'Connor.
Yes.
Representative Toole. Absent. And Representative Ziegler.
Yes.
10 yes, 3 absent.
All right. Thank you, everyone. So I believe that ends our work session on LD 743, and we'll move back into our next public hearing for LD 780, and we will welcome Representative Fay. Again, welcome.
Thank you, Senator Brenner. Thank you for having me back. Senator Brenner, Representative Tucker, and esteemed members of the Environment and Natural Resources Committee. I'm Jessica Fay, representing the people of House District 66, parts of the towns of Casco, Poland, and Raymond. And I'm pleased to introduce LD 780, an act regarding uncontrolled hazardous substance sites. This bill is being proposed again by the Department of Environmental Protection. It modifies the definition of hazardous substance in the Uncontrolled Hazardous Substance Sites Law. I'm presenting this change proposed by DEP, which incorporates amended language that this committee passed last session but died when the 129th legislature adjourned. The Uncontrolled Sites Law is the state's equivalent of the Superfund Law, giving the DEP the authority to respond to hazardous substances that may endanger public health or the environment. It allows the department to investigate the extent of contaminant releases, determine the risk, and mitigate that risk. DEP would like to be able to handle these newly discovered chemicals and other future chemical threats in the same way that it has handled emerging contaminants over the past 30 years. This change will help address recent concerns about health effects from emerging contaminants, such as per and polyfluoroalkyl substances, you know them well as PFAS, and residues remaining after emergency removals of bulk chemicals from clandestine methamphetamine labs by allowing the department to use its remediation program to appropriately address health risks posed by current and future contaminants. PFAS have been widely used in commerce, and they are highly persistent, move further and faster through the environment than other contaminants, and present risk at relatively low concentrations. Similarly, EPA research suggests that chemical and drug residuals that remain after emergency responses at illegal drug labs pose a significant risk warranting remedial action. I'll let the department answer any questions you might have about this legislation and why it is part of addressing the PFAS issue, the meth labs, and future chemical contamination threats that we might not yet understand. I thank the committee for your attention and look forward to working with you on this issue.
Thank you, Representative Fay. Are there any questions from the committee? All right, not seeing any. Thanks for joining us. We'll bring you back in a couple of minutes. And I believe next up from the DEP is David Wright. Mr. Wright will join us next. Welcome, Mr. Wright. There you are. We can see
All right.
you. Welcome.
And can you hear me as well?
We sure can.
Great, thanks. Okay, Senator Brenner, Representative Tucker, and members of the committee, thank you for taking the time today to address the agency-sponsored bill, which was first introduced last session. And thank you, Representative Fay, for sponsoring this bill. My name is David Wright. I'm the Director of the Division of Remediation, a position I've held for the past 13 years of my 32-year career at DEP. I'm here today testifying in support of LD 780. So DEP is proposing to modify the definition of hazardous substance in the Uncontrolled Hazardous Substance Sites Bill. The Uncontrolled Sites Law is the state's equivalent of the federal CERCLA or Superfund law, giving the department authority to respond to hazardous substances that may endanger public health or the environment. The reason DEP wants to modify this law is because we think it's the best approach to address human health and the environmental impacts from historic releases of emerging contaminants such as per and polyfluoroalkyl substances known as PFAS and residues remaining after emergency removals of bulk chemicals from illegal drug labs. DEP wants to handle historic releases of these newly discovered chemicals the same way that we have been handling emerging contaminants over the past 30 years. However, a recent opinion from the Attorney General's office suggests that DEP may not have the legislative authorities for these particular chemicals. So the immediate problem we are trying to address is the risk from historic releases of PFAS and drug residues. I'm not going to go into a lot of detail here. Just from the 10,000 foot level, PFAS are chemicals that have been widely used in commerce since about 1938. They are highly persistent, meaning they don't break down in the environment once released, say like petroleum does. Many of them move further and faster through the environment than other contaminants. And most troubling, they present risks at very low concentration. Similarly, chemical and drug residues that remain after emergency responses at illegal drug labs pose a significant risk warranting further remedial action. So while PFAS are the latest emerging contaminants, others are likely to follow. EPA has inventoried over 86,000 chemicals that have been used in the United States. Under the TSCA reforms of 2016, EPA is slowly reviewing the risks posed by these chemicals. As this work is completed, we will find other legacy chemicals that need to be addressed. So we think rather than creating a whole new program, the most efficient and least disruptive approach is to use our existing well-developed remediation programs. We want to use the existing private and government infrastructure that we have developed to address chlorinated lignins, chlorinated solvents, dioxins, PCBs, PAHs, and a host of other chemicals that over the past 30 years were once emerging. We also want to be sure that we can address future emerging contaminants in a timely manner. In order to do this, we are seeking a modification to the Uncontrolled Sites Law, because the Uncontrolled Sites Law is the linchpin for the state's infrastructure for investigating the extent of historic contaminant releases, determining the risk to public health and the environment, and mitigating that risk. Here's how the program works on newly emerging contaminants. First, we work with stakeholders to understand the science and potential risks posed by historic releases of contaminant. We work with responsible parties and other stakeholders to identify the location of all potential sites, rank the sites based on risk, develop a consistent, efficient approach to address that risk, and then address the risk working first on the sites that pose the greatest risk to the greatest number of people. At each individual site, we work with stakeholders. We take a science-based approach. We use standard practices that have been developed by national and international experts and foster creative problem-solving approaches. The mission at each site is to prevent current and future exposure to site contaminants. We do this in a step-like process, first assessing the extent of contamination, assessing the risk it poses, developing alternatives to address any risk, selecting a remedy, and then design and implement the response action. We also monitor post-remedial care when wastes are left in place at the site. So turning now to some nuts and bolts of this bill. This bill was introduced last session and a majority ought to pass vote occurred in this committee, but it was never voted on by the full legislature due to the pandemic. So we are reintroducing the bill as it was amended by the majority ENR committee members. So some more details. The specific modification to the Uncontrolled Sites Law that DEP is seeking is to include in the definition of hazardous substance anything defined under CERCLA as a hazardous substance or pollutant or contaminant. For specific language, please see the excerpted language from the definition sections of CERCLA and the Uncontrolled Sites Law that is attached to my written testimony. This change will allow the department to use the Uncontrolled Sites Fund to investigate and mitigate risks posed by emerging contaminants, or require responsible parties to undertake remedial work. Note that the Uncontrolled Site Law contains several due process provisions for responsible parties. First, before ordering cleanup, the commissioner must formally determine that the site poses a human health or environmental risk. This is done by demonstrating the hazardous substance exceeds a risk-based concentration at the site, that there are people or environmental receptors at or near the site, and that there's a pathway that connects these two. Secondly, the commissioner must demonstrate that the remediation is necessary. The commissioner's determination that a site poses a risk and that remediation is necessary is appealable first to the Board of Environmental Protection and then to the courts. Additionally, the Uncontrolled Solid Law provides other protections. The uncontrolled sites law provides liability protections for responsible parties that undertake due diligence prior to purchasing a site. It provides protections to municipalities that foreclose on a site, lenders, and fiduciaries. The department also operates a voluntary response action program called VRAP, under which an applicant investigates and remediates a site in exchange for a release from liability for known conditions. This is often done as part of a real estate transfer. The state has a robust brownfields program to help qualifying applicants pay for the investigation and remediation at these sites. And remediation of orphan sites has been historically funded through bonds. So in summary, we believe that this modification is necessary to address current public health and environmental risks from PFAS, residues at illegal drug labs, and other emerging contaminants. This concludes my prepared remarks, but I'm available to answer questions now or at work session.
Are there any questions for Mr. Wright from the committee? Yes, Representative Tucker.
Thank you, Mr. Wright. The EPA's list of pollutants or contaminants is quite lengthy. So my question is, will this proposed legislation automatically adopt every chemical on the pollutant or contaminant list, or will it simply allow our commissioner of the DEP here in Maine to designate one or more of those substances as hazardous under the Maine Act?
Yeah, so the CERCLA list of hazardous substance that is already incorporated into the list of hazardous substances under the uncontrolled sites law. So all those chemicals are already listed, but if you look at that list, it does not include the most dangerous chemicals from clandestine drug labs, your fentanyls, your methamphetamines. And it also doesn't include many, if any, of the PFAS compounds. And so the proposal that we have is, rather than identifying and adding chemicals on a compound by compound basis, we would look at the properties of those chemicals to determine if they pose a risk, and then be able to investigate whether people are drinking contaminated water or not drinking contaminated water, and whether that exposure poses a risk to them, and whether steps should be taken to or are needed to mitigate that risk.
I don't understand. I thought the purpose of this bill was to allow designation for the state's purposes of a hazardous compound, those chemicals and substances which are already on the pollutant or contaminant category of the EPA. Am I wrong on that? Have we already incorporated all those substances on the pollutant and contaminant list?
Yeah, so there's two definitions in the CERCLA law. One is for hazardous substances, and the second is for pollutants or contaminants. And pollutants or contaminants is like one word. So the hazardous substances are a list of specific chemicals and chemical groups that EPA has listed as hazardous substances. And it was basically adopted from the list of known bad actors in 1980. And then EPA also has a definition of pollutants or contaminants, and that is a general definition of the potential health impacts that a chemical could have. And what we're trying to accomplish is to be able to address these newly emerging contaminants in a timely manner, so that that would be added to the state's definition of hazardous substances.
Okay, thank you.
Any additional questions for Mr. Wright? Yes, Senator Bennett.
Thank you, Madam Chair. I'm really kind of, I really benefit from a greater explanation of the purposes of the liability carve-outs in this bill. They give me a lot of pause, frankly. And I'd like to understand the genesis of those and the impacts that you expect those to have.
Yeah, so those carve-outs were introduced during the last session through testimony and compromise worked out through this committee. That was the language that was voted on by the majority of the committee ought to pass. And so rather than starting at square one this year, we thought we would take advantage of the work that the committee did last session prior to having to adjourn due to the pandemic. That was the genesis of them.
This is your bill, right?
Yes, it is.
Can you explain why those good public policy?
Mm-hmm.
From the department?
So the public policy that's at issue in the carve-outs are for publicly owned treatment works and water treatment works, the residues from those that were used primarily as agricultural amendments of farmers' fields. So the public policy issue is expenditures for investigation, remediation of sites caused by those residues would go back to the ratepayer, and so to the local taxpayer, basically. And if it's an orphan site, then the state taxpayer is going to pay for that. So the discussion that was held last session was whether it was appropriate for these emerging contaminants to be funded by the state taxpayer or the service center taxpayer. And that was, this is where the committee landed.
Okay. Well, I wasn't on the committee. I was in the legislature the last time around. So I'm looking at this ab ovo, and I would really appreciate for the work session a better understanding of the potential impacts of this carve out, particularly downstream. What I'm concerned about is that people on whose property the sludge may have been spread, will not be able to go back to any public authority here, which has frankly the ability to go back further upstream and get liability out of others than probably the private property owner might, who's suffering with this spread of sludge, for example, that contains PFAS. So if you could provide that, the other aspect of which I find troubling is that it gives, as it's written currently, the DEP commissioner a lot of authority as a member of the executive branch to determine liability coverages for entities, and I think it's kind of a mix of powers there between an executive and a judicial character. And I'd like to see if we have anything like this elsewhere in current law, where a commissioner has the ability to determine who might be liable or not based on their operating practices for anything, any sort of issue. I've never heard of this before. Maybe there's a precedent in law. Maybe that's why it was written that way. But there's a lot about that which I think really we want to know very clearly what the implications are of that section of this bill, and anything you can do to provide information to the work session would be most helpful.
Okay.
Thank you.
Mr. Wright, I have a question for you. You mentioned that there were stakeholder groups who would determine what sites get tested.
Yeah.
Can you give me a little bit more information about what kind of folks make up a stakeholder group that would determine testing of sites? I'm
Sure.
thinking particularly of farmland.
Yeah, sure. I can go back to a previous experience that we've had. So with this, like the dry cleaner initiative, that was a host of areas that were contaminated with perchloroethylene from a dry cleaner. So as we began to realize that that posed an indoor air risk at both the dry cleaner and adjacent residences, we worked with the Interstate Technical Regulatory Commission, the dry cleaning industry, residents that abutted some of these sites to figure out a common sense approach to, and also the environmental community, the environmental consultants, to figure out a rational, comprehensive approach to take at these sites. So, we would hold a series of meetings, discuss what the real risk is, what the risk isn't, and then how would you address that risk? And then we realized that a lot of the technology to address the risk had been created by the radon industry, and so radon control industry. So we brought in those folks into the conversation. So I don't know if that answers your question, or you want more specifics on how we might approach the PFAS issue.
Yeah, I guess I am specifically interested in what the plan is for the cooperation with the Department of Agriculture around farms that have had biosolids spread on them over the years, and whether or not we are envisioning that those would be included in this testing program that you're talking about as part of the bill.
Yeah, so the biosolid sites, those are currently being handled under the solid waste programs, which is outside the uncontrolled sites program. So I know that the department has been working closely with Department of Agriculture on that situation, and that they are working on establishing a holistic testing program. Because it's not in the remediation program, I don't know the specifics of that, but we could get that information to you if you were interested.
Great. Yeah, that'd be helpful. Thank you. Any more questions for Mr. Wright? All right. Thanks for joining us this morning.
Thank you for the opportunity.
Mm-hmm. All right. And now if there are other folks within the attendee space that are here to speak in favor of LD 780, if you could raise your hands, that would be great. And we'll bring you over. All right. Sabrina, we'll go in this order. Sarah Woodbury, Lonnie Graham, Sharon Treat, and Mark Highland. Welcome, Ms. Woodbury. Good morning.
Good morning. Thanks for having me. So good morning, Senator Brenner, Representative Tucker, and members of the Environment and Natural Resources Committee. My name is Sarah Woodbury. I am the Director of Advocacy for Defend Our Health, formerly the Environmental Health Strategy Center, and I am here to testify in support of LD 780. We are all well aware of the story of Fred Stone and his dairy farm and how his livelihood was ruined by PFAS contamination. As a result of state-sanctioned spreading of industrial and municipal sludge, Fred Stone's land is now practically worthless, and Fred Stone is not the only farmer or landowner impacted. We have all seen the recent stories about the Tozier farm, along with the at least 54 wells on the property surrounding the farm in Fairfield that have been contaminated by toxic PFAS. And just also, in addition to that, the DEP mentioned last week that they're starting testing in Benton and Unity Township and also expect to find similar issues there. So, on top of that, adding insult to injury, DEP is unable to access existing state resources to address the contamination found on these contaminated sites, since PFAS are not amongst the chemicals listed as eligible under the Uncontrolled Sites program. As a result, the chemicals from Fred's land likely continue to leach into the aquifer and likely into the Kennebec River that flows next to his farm. Additionally, PFAS contamination on the Tozier farm likely continues to leach from the soil into the surrounding areas. The state currently has no authority to access funds that could be used to plan for remediation and cleanup. LD 780 is necessary to provide DEP with the flexibility to address not only the Stone Ridge Farm, Tozier Farm, and Fairfield well situations, but others that will surely arise. DEP has identified approximately 500 other sites across the state that receive sludge similar to Stone Ridge and the Tozier Farms. Only a handful have been tested. Given the ubiquity of PFAS use, it is likely more sites will be found. This will also allow the DEP to tackle the next PFAS or other emerging threat that will inevitably rise. Mainers deserve to have a DEP that is empowered to quickly identify and respond to hazardous substances found, both to limit further contamination and to begin the process of holding responsible parties accountable for their actions. Under the current Maine statute, we have to wait for federal government to identify hazardous substances. As Governor Mills said in her 2020 State of the State, we are not Washington, we are Maine. We should not have to wait for Washington to act to protect our communities from hazardous substances. LD 780 would allow DEP to make these determinations using the same definitions that the federal government does without waiting for Washington. Defend Our Health urges you to unanimously support ought to pass on LD 780. Thank you for your time.
Thank you so much, Ms. Woodbury. Are there any questions for Sarah? All right, not seeing any. I want to take just a pause to have Senator Carney introduce herself. She's joined us before we continue.
Thank you very much. Good morning, everyone. I'm Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, and a little bit of Scarborough. Happy to be here. Sorry I was late. I was in another meeting.
Well, we're glad to have you. All right, and next up is Lonnie or Lanny Graham. Have to let me know if it's a long or a short A.
Good morning, Senator Brennan, Representative Tucker, members of the committee. My name is Lonnie Graham. I am a family practice physician and former Chief Public Health Officer for Maine. Currently, I serve on the Public Health Committee of the Maine Medical Association, and from May 2019 to December 2019, I represented the Maine Public Health Association, working on a task force established to make recommendations to help Maine address the very serious contamination by PFAS. As my area of expertise is health, I want to briefly mention this family of chemicals has already been shown to be associated with potentially very adverse health effects, including decreasing the normal responsiveness of the immune system, decreasing a woman's chance of pregnancy, and increasing thyroid disease and the occurrence of several cancers. As a member of the task force, I am very well aware of how hard the government agencies worked over the last several years to address Maine's PFAS problem, with woefully insufficient resources and a relatively unresponsive federal government. My hat is off to them. Everything was thought through to determine where risk was highest, with a view to protecting the most vulnerable Maine people. But sadly, there's no way to address this problem without additional authority and funds. This bill offers that opportunity and was part of the DEP plan developed in collaboration with the PFAS task force. Unfortunately now, as in the past, from a public health point of view, we are often in the role of reacting to terrible contaminations long after the actual contamination has occurred. Perhaps if DEP had had this authority several years ago when alarms were raised by other jurisdictions, more rapid action would have been feasible. And perhaps this bill will give Maine a better chance when future contaminations threaten us, which sadly they almost certainly will. Thank you for your attention.
Thank you, Dr. Graham. Any questions for Dr. Graham? All right, not seeing any. We thank you so much for joining us this morning.
Thank you.
Hello there, welcome.
Thank you very much. Good morning, Senator Brenner, Representative Tucker, and honorable members of the Environment and Natural Resources Committee. My name is Sharon Tree and I live in Hollowell, and I'm senior attorney for the Institute for Agriculture and Trade Policy. And I'm testifying today in support of LD 780, an act regarding uncontrolled hazardous substance sites. I2P is a nonprofit headquartered in Minneapolis, Minnesota, but we have offices in other places, including my own office here in Hollowell. And we work to promote local, sustainable, and environmentally beneficial agriculture. As PFAS has increasingly been found to have contaminated food and farms, we have been advocating for measures to investigate and remediate this pollutant. We testified in support of legislation last year on this issue, and we support this bill today, which grants DEP clear authority under the Uncontrolled Sites Law to clean up and remediate PFAS contamination, as well as other contaminants that aren't currently on the CERCLA list, to make sure that responsible parties pay. I think it's very important that this legislation be passed not only for PFAS, but also for the other chemicals. As David Wright pointed out, the original list is based on a 1980s era list of chemicals, and a lot has been done recently that has identified many more, including with the updates to the CERCLA law in the most recent couple of years in Congress. As has been pointed out, DEP has identified over 500 properties with sewage or industrial sludge was spread over the last 40 years. Water contamination around hundreds of closed landfills is also likely based on DEP testing so far, which has found numerous cases of that. Industrial and military facilities using PFAS firefighting foam, which you'll hear about more later today, has also contaminated soils and water. And basically, we just don't know where PFAS contamination will show up next. As I've illustrated in the maps that I have in my written testimony, PFAS has characteristics that increase the complexity and cost of uncontrolled site investigations and cleanup, and that virtually guarantee that contamination from these so-called forever chemicals will continue to pose serious environmental and health risks for years in the future. This is because PFAS is so mobile, traveling great distances in groundwater from where contamination began. It bioaccumulates in soils and organisms so that higher and higher concentrations are possible, well away from the source of the pollution. And it is so persistent that it lasts practically forever without breaking down. Passing LD 780 will enable the state to act much more quickly than it has to protect the public and the environment from this harmful family of chemicals, and also be able to assess responsibility and get payment so that the entire cost of cleanup and remediation does not fall on the state taxpayer, nor on people who are not truly responsible for the pollution in the first place. So thank you very much for your attention, and I hope you'll vote this to pass.
Any questions? Yes, Senator Bennett.
Thank you very much, Madam Chair. Senator Treat, nice to see you as always. I would really appreciate knowing, I know you're represent a nationwide group. Do you have any information about the state of litigation surrounding PFAS contamination against private actors in or others around the country?
There's a lot of it. And I can certainly, if you're interested in more chapter and verse on the particulars, I could get you some more on that, but there is a lot of it. I mean, some of it, I think Maine has been in a situation where like a lot of that litigation has been around particular industrial facilities that dumped stuff into waterways, et cetera. And so it was the nexus between who the polluter was and the pollution was more clear than in some of the instances that we're seeing cropping up here in Maine, which is kind of why it really relates to this uncontrolled sites bill, because that's about when you don't know who, someone hasn't taken responsibility and you don't know who it is. You need that legal authority to go back and find out who they were and investigate it and then go after them. So that, that's one reason this is so important, but certainly, yeah, there's a lot of litigation, and personally, not just because I'm a lawyer, I really think that state of Maine needs to be going after these responsible manufacturers and others and not have the entire cost of this being on taxpayers and others that really, aren't responsible for what's going on right now.
Thank you. Well, you underscore one of the reasons I'm concerned about the liability carve-outs in this bill, because we don't really know who is responsible, and we ought not to be letting people off the hook until we do. And so, and I also, recognize who has the more comprehensive ability to go after some of the underlying players here, and it is often not, a farmer down in southern Maine.
Right. I mean, just to be clear, in this particular bill, those exceptions were focused on publicly owned treatment works and water facilities. And, I think having actually attended two different conferences or more of water utilities and sewage treatment facilities were huge. And the reason I got into this subject in the first place was attending these and finding out that PFAS was this enormous problem that sort of got dumped in their lap, and that they don't really have the wherewithal to deal with, and with either technically or financially. So, so from my perspective, I mean, this stuff is coming from manufacturers. There are alternatives to it, and it's continuing to be used as a ingredient in many products. So that is where a lot of the liability needs to go, among others that may have known what was really the harm here and continue to say spread it or do other things with it.
Thank you, Senator. I call you Senator, forgive me.
I don't mind.
Thank you so much for joining us. Are there any other questions from the committee? All right, thank you, Senator.
You're welcome, thanks.
Have a great day. And next up, I believe, is Mr. Highland. Welcome, Mr. Highland.
Okay, can you hear me okay now?
We can hear you, but we can't see you. So if you want to.
Oh, okay, that's weird.
That's always nice too.
Cameras, let's see, start video maybe?
No pressure.
Thanks.
There you go. Hi.
Senator Brenner, Representative Tucker, members of the Environment and Natural Resources Committee. My name is Mark Highland. I'm the chair of the board of directors for Defend Our Health. I'm also the former retired director of the Bureau of Remediation and Waste Management for Maine DEP. And prior to being a bureau director, I was also the director of the Division of Remediation, which had the responsibility for the cleanup of Superfund sites, landfills, hazardous waste sites, and uncontrolled sites around the state. And I did that for many years. I have to tell you, I've spoken with Fred Stone at great length. I've seen his farm, and you probably have all heard the story. I live in a farming community. In fact, I live right down the street from Representative Fay, who I'm glad to see here on the committee too. And farming is one of our basic jobs here in the community I live in. And Farmer Stone, or Fred Stone's facility, is a family operation. Both his daughter and son-in-law work there too. And of course now they don't work there because of the PFAS contamination that we've seen. And the real problem here is that DEP doesn't have an ability to act on this, and it's because of the fact that the PFAS and PFOAs are not listed as hazardous substances. This bill is an attempt to correct that, and I think that's a great step. In my years at DEP, I sat in the living rooms of people whose drinking water was contaminated by hazardous substances. Sometimes it was Superfund sites, sometimes it was military bases, sometimes it was other types of facilities. Almost all those people are fearful, they're angry, and they wonder how this could have happened to them. They're also concerned about their family's health and safety and how long they've been drinking this water or being exposed to this contamination. and they want answers. And unfortunately, DEP's in the unenviable spot of not being able to give them answers and not really even being able to give them much help. And so they need our assistance. Imagine having a DEP staff member tell you that your drinking water is contaminated. That's the biggest shock of all for most people. And then say that not only can it be used, but they don't have a good way of helping them. In my years of experience, we were able to at least tell people, yes, your water may be contaminated, but we can help you, and we can move to either put filters on or replace the water supply in some fashion. And here, the DEP can't even do that. So that's the biggest reason for making sure that the DEP has the flexibility to name these substances. And I guess think about that. I mean, many of you survived maybe the ice storm, or maybe you've been out of water for a period of time. My family, in fact, was out of water for about 3 months when our well failed one time. But try and do your daily tasks and daily things without being able to drink your water or actually turn the water on in your house. That's a pretty tough thing for anyone. So LD 780 is necessary to provide DEP with the flexibility to address not only the Stone Ridge Farm situation, but also the ones in Fairfield and some of the other places around the state. And they've identified 500 sites around the state that have similar problems, and it's likely that a lot more of those sites will be found. We've been spreading sludge, municipal treatment plant sludge, in the state for almost, it's been a little over 40 years now, almost 45 years. So there's a lot of places around the state that have the potential to be a problem. Mainers deserve to have a DEP that's empowered to quickly identify and respond to hazardous substances found, both to limit further contamination and to begin the process of holding responsible parties responsible. In particular, I heard Senator Bennett's questions, and the carve-outs I think are reasonable here, and the reason for that is this. Both the Superfund site and the hazardous waste and the uncontrolled sites law worked on strict joint and several liability. And that means that anybody that's involved in the process, from trucking the material to collecting the material to actually producing the material, is somehow responsible for that. And that's how our RCRA law, the federal RCRA law, works. It's known as cradle to grave. So you have responsibility from cradle to grave for any hazardous substances or hazardous wastes that are produced. The problem with this particular PFOA situation is that publicly operated treatment works or municipal wastewater treatment plants don't have the ability to deny a waste stream from coming into them. They don't have the ability to say, no, you can't send your wastewater to us for processing. And so that's why the carve-out's in there. And it just keeps them out of the liability loop, because frankly, they didn't have any liability for putting the substance into the wastewater. What they had for responsibility was to actually collect the wastewater and treat it and produce a waste. And it seems like a reasonable approach to me, based on how complicated these liability discussions can get between responsible parties. And so I recommend to the committee that you and I urge you to vote ought to pass on this and give the DEP flexibility not only to name new hazardous substances, but also keep people who are really not liable for the spread of this contamination out of the liability framework that would complicate matters. If you have any questions, I'd be happy to answer them. Thank you.
Thank you, Mr. Highland. Are there any questions for Mr. Highland? Yes, Senator Bennett.
Thank you. When I saw you're listed on the committee's website with your material, next to your name it says Poland Spring, and I assume that it has to do more with residents than it does with the company. But it's sort of an implied connection between the with a bottling company or with a brand, and I just wanted to clarify that for you. I think yes.
No, I don't, and have never worked for Poland Spring Bottling. They are down the road from me, not very far. You're probably familiar with the area. I'm up on Range Hill Road, which is kind of eastern Poland, which has always been known as the Village of Poland Spring. But no, I'm not a member of the company. And unfortunately, Representative Fay is not my representative because I live about a half mile too short of her district.
Well, thank you. I just wanted to clarify that for anybody that might have misread it as I did originally.
Yeah, no, not speaking for Poland Spring Bottling, clearly.
If I could just ask a question, and thank you for attending to my questions earlier. Are you familiar with your background at DEP of any situation where the commissioner is given the ability to choose who's liable and who isn't?
That's a good question. There were certainly cases where we used prosecutorial discretion to not go after a responsible party.
Which is a separate matter, right?
That's a separate matter. Because we didn't believe they were liable or they had liability in that situation. But certainly in the case of if there's a court case or if responsible parties go to sue each other as a result of a cleanup, the commissioner's discretion really doesn't enter into it, I would say.
Thank you.
Any additional questions for Mr. Highland? All right, thanks for joining us this morning.
Thank you.
All right, and I believe that is everybody that had signed up to speak in favor of the bill. If I'm missing anybody and you're in the attendee space and that's what you're here for, please raise your hand. All right, anybody here to speak in opposition to the bill? There is not anyone signed up to speak in opposition. Oh, but we do have a hand up. All right, let's bring Mr. Strzok over. Welcome.
There we go.
Good morning. You're here to speak in opposition.
Yes, I am.
Welcome.
Ready to go? Let me make sure I don't cut off my head. Senator Benner and Representative Tucker and distinguished members of the Environment and Natural Resource Committee, I'm Patrick Strauch. I'm the Executive Director of the Maine Forest Products Council, and I live in Exeter, Maine. I'm here representing Maine's forest products manufacturers who, together with logging and landowner sectors, represent about $8 billion in economic contribution to the state's economy and more than 33,000 direct and indirect jobs. We're speaking against this bill, but we're supportive of revisions to the Maine Uncontrolled Hazardous Substance Sites Law to reflect more accurately the provisions in the federal CERCLA law or Superfund law. And we think it's important to enable Maine Department of Environmental Protection to take action on contaminated sites. So we're dedicated to trying to make that happen. However, the language in LD 780 creates authority for the DEP that exceeds what CERCLA has for authority, including terms pollutant or contaminant in the definition of hazardous substances. These are terms that are in the CERCLA law, but not the reciprocal limitations on this designation in the CERCLA law greatly expands the authority of DEP. Under CERCLA, EPA can expend its own money to clean up sites designated with pollutants and contaminants, but it cannot recover costs or issue orders to private parties as allowed under the hazardous substance designation. And we believe it's those hazardous substances that transfer into the Maine law. Essentially, EPA assigns lifetime liability to materials officially designated as hazardous substances, but only limited authority to pollutants or contaminants. The definitions for pollutant and contaminant were adopted to allow EPA maximum flexibility to do cleanup on a variety of materials without forcing EPA to go through rulemaking. In other words, to allow EPA to tackle emerging threats at government expense without delay. And that is the situation I think we're in here. We want the state to be able to take action on these sites. And I think they can do that. I think we in the last session put forward an amendment that had the ability for the state to have the investigative authority, could use its emergency authority to take control of the sites, secure the uncontrolled site, eject all persons, dispose, treat, or otherwise handle all hazardous substances. And it would allow the state to accept funds from federal sources, as the governor is trying to put forward as we speak. This amendment would match federal CERCLA Superfund structure in the main uncontrolled sites law to enable DEP to take action on a class of emerging substances that have not yet been listed hazardous substances by EPA, but not assign lifetime liability for these compounds until they are listed as such by EPA as hazardous. It's important. I think last session people thought that this bill would allow the state to go after DuPont or 3M, but that's not what this bill does. It applies to main businesses, both large and small. The polluters, in many cases, were doing what DEP encouraged and licensed them to do. So it's an interesting dilemma that we've got. So I'd be glad to meet with DEP to discuss revisions to the bill that achieve their objectives and enable action to take place to secure and remediate contaminated sites without delay. So thank you. I have in my testimony a copy of the description and the amendment, how it might be worded, and then some definitions of under CERCLA that define hazardous substance and pollutant or contaminant, so you can see the difference. Thank you very much.
Thank you so much. One thing that I'm not seeing in our website is your written testimony. So you might need to resubmit it, or perhaps you can email it to the clerk, and Sabrina can pop it up there, but I don't see that as I'm trying.
Yeah, and you didn't have me listed as testifying either.
Well,
so.
yeah, I'm noticing you signed up at 9:30, and I had already looked at the list, and so my
Oh, okay. Yeah.
I apologize.
Probably 9:31 is what I signed up for. So that explains it all. Thank you.
Yes, thank you. Representative Hanley has a question for you.
Yes, thank you, Madam Chair. Thank you for your testimony. Has the department looked over your amendment, and do they have an opinion of it?
They looked over it last time, and I think did not want to really go that way. Did not express interest in it, to be honest.
Follow up, if I may.
Yes, please.
Did they give you an explanation of why they weren't interested in that amendment?
Well, I think they leaned heavily on their record and the fact that we should trust them, that they weren't interested in undermining an industry. And I understand that, but I'm used to dealing with the letter of the law and protecting people. That's what we do. That's what all you folks do. And it was my interest to make sure that we put together good statutory language that followed that protocol.
Thank you.
Thank you.
Any other questions? All right, not seeing any. Thank you for joining us this morning.
Thank you.
Good to see you. And is there anyone else in the attendee space here to speak in opposition to the bill? All right. Not seeing any, then we will call for folks that are here to speak neither for nor against the piece of legislation at hand, which is still LD 780. And we'll go in this order: Mr. Sawyer and then Mr. Goldberg. Welcome, Mr. Sawyer.
Thank you very much, Senator Brenner. When it jumbles you, there's quite a lot to reorganize.
Yeah.
Senator Brenner, Representative Tucker, and members of the Joint Committee on Environment and Natural Resources, thank you for the opportunity to speak today. My name is Brad Sawyer. I'm the Director of Government Affairs for the Maine Rural Water Association. Rural water recognizes the role wastewater utilities will play in the battle against PFAS, and we look forward to playing a role in these conversations and in the future. LD 780 represents an increased list of items that the state may consider when initiating remediation activities. We recognize that this is similar legislation to LD 1923 from the 129th, and that was likely on track to pass before the COVID-19 pandemic. While broadly expanding that list concerns some of our members, we feel that the language included in sections 1A and 1B are sufficient to protect utilities acting in good faith in the wastewater industry and water industry. As an industry, we appreciate that this legislation includes those carve-outs, and the one hope is that the committee sponsor or department could clarify the language best management practices for disposal on page 1, line 34 and 35, and page 2, line 4 and 5. We believe this is reasonable language and support its inclusion, provided that it is referring to best management practices for disposal at the time of action, not based on new standards applied retroactively. As has been pointed out, as we learn more and move forward in the future, there will undoubtedly be things that we learn that we don't know today. And we feel that penalizing a utility due to information that didn't exist at the time has potential for never-ending legislation. There seems to be agreement that utility ratepayers and taxpayers should not be responsible for the large majority of PFAS remediation costs. They do not create these compounds, and in many cases, we're unknowingly using them or receiving them for decades. We support the idea that producers and intentional users of these compounds be responsible for remediation, and believe LD 780 can play a role in that goal. Thank you for the opportunity today, and I'd be happy to try to answer any questions.
Thank you, Mr. Sawyer. Senator Bennett has a question for you.
Thank you, Madam Chair. Mr. Sawyer, thanks so much for your testimony. What do your members typically have insurance, liability insurance for a range of things? How does that work?
I believe.
I'm sorry, you're breaking up.
I believe to exactly what that covers.
Mr. Sawyer, you might want to turn off your video because we're losing your audio. There we
Sorry,
go. That's better. Let's try that.
Half a mile from the state, I always expected isn't always the case. Thank you. Yes, as they do. I couldn't speak to exactly what each utility.
I'm sorry, I can't hear you. We can pick this up in work session. I'd really be interested, Mr. Sawyer, if you can hear me in sort of understanding what's typical for liability protections for members and whether defense costs, et cetera, about some of this PFAS contamination would fall into that usual bucket of liability coverage that your members might have. Thank you.
All right. So, Mr. Sawyer, if you can hear us, because we're losing the ability to hear you, if you could provide that to us for the work session, that would be wonderful. All right. And next up is Mr. Goldberg. Welcome, Mr. Goldberg.
Hello. Senator Brenner, Representative Tucker, and members of the Environment and Natural Resource Committee. My name is Neil Goldberg, and I am providing testimony neither for nor against LD 780 on behalf of MMA's Legislative Policy Committee. I don't have much to add in support of the bill beyond what you've already heard. These are hazardous chemicals, and we need to be identifying and mitigating their presence in and around our state waters and grounds. The concern for municipalities and our members is to what extent they are going to be the responsible parties. Prior to this morning, I personally wasn't aware that clandestine drug labs were also a target of this bill. And that adds to some of the potential responsibility that municipalities will have in the future as these fall into their possession. We are also aware that these compounds, these hazardous substances are easily transmittable through the water. They are hydrophilic and can spread quickly to other municipalities and other properties. And again, to what extent do those publicly owned places become the responsible parties for mitigation? At the moment, DEP is saying that they would spearhead this, but how much of it will they pass along to the municipalities, both as staffing as well as the financial responsibility? So until those are resolved, we stand neither for nor against. I'm happy to answer any questions. Thank you for your time.
Thank you, Mr. Goldberg. And Senator Carney has a question for you.
Thank you very much, Madam Chair. Thank you for being here to testify, Mr. Goldberg. I've had a question that I've wanted to ask a lot of the other folks who have spoken, and they didn't seem like the right person to answer, but I think you might be able to. What is the role of the Maine Tort Claims Act absolute immunity provision and exceptions to immunity with regard to claims involving PFAS and also the drug manufacturing labs in claims against municipalities?
A great question that I would be happy to bring to our legal department and get back to you for the work session or via email. I'm not able to address that. And again, was just this morning cued into this underlying issue of drug labs. And so I want to get more information on that before our work session. I'm sorry.
No need to apologize. It would be really helpful to have that information. Thank you.
Mm-hmm.
Any additional questions for Mr. Goldberg? All right, thank you for joining us this morning. Okay, are there any other folks in the attendee space that are here to speak neither for nor against? Mr. Wade. And if there's anyone else over there who's here to speak for the bill, neither for nor against, or for or against, if you could raise your hand so that I can just know you're out there. Welcome, Mr. Wade. Good morning.
Hi. Good morning, Senator Brenner, Representative Tucker, and other distinguished members of the ENR committee. My name is Tim Wade, and I'm representing the Maine Water Environment Association, or MWEA, as I will refer to it. And I'm representing MWEA as the chair of the Government Affairs Committee. I appreciate the opportunity to provide the following testimony, neither for nor against LD 780. MWEA is a nonprofit all-volunteer association of over 650 individual members. We represent a diverse group of water quality professionals throughout the state, including wastewater treatment plant operators, sewer collection system operators, utility system administrators, consulting engineers, suppliers, contractors, and other vendors. The mission of MWEA is to support and enhance Maine's water environment community through promoting training opportunities, supporting balanced environmental policy and practice, and promoting education and collaboration with the public to protect and enhance Maine's water resources. MWEA fully supports a comprehensive cleanup of sites contaminated with hazardous materials. In the past, we have provided testimony and worked with your group and the department expressing concerns related to the potential liability of our members that operate these POTWs, or publicly owned treatment works, more commonly referred to as wastewater treatment plants. Because the POTWs are receivers of these contaminants and not users of hazardous substance, we believed those POTWs that responsibly manage their biosolids, strictly adhering to state and federal management requirements, should not be considered potentially liable parties under the state and federal cleanup regulations. That position was previously acknowledged and addressed in this bill, and we sincerely appreciate that consideration. Also like to thank Mr. Highland for echoing our concerns in regards to that liability clause. We do continue to express concerns about the breadth of scope of future unknown emerging contaminants and how their addition could impact our members' facilities, including the vendors who receive our biosolids. Major expansion of scope of the contaminants could severely undermine the program's ability to effectively clean up identified hazardous substance sites. In conclusion, Mawia largely supports the intent of LD 780 and hopes that its focus remains on the cleanup of sites that have been contaminated by identified hazardous or toxic substances. Thank you for your time and attention. I will try to answer any questions.
Thank you, Mr. Wade. Does the committee have any questions for Mr. Wade? All right, not seeing any. Thanks for joining us this morning.
Thank you.
All right, and I don't see any more hands up in the space to speak neither for nor against the bill or for the bill at all. So I'm going to just call one last time. And then we will go ahead and we will close public hearing on LD 780. And we will move on to a public hearing for LD 960. An act to require reporting of PFAS in products and of discharges of firefighting foam containing PFAS. And we'll invite Representative Fay back in to introduce the bill. Welcome.
Thanks again. I'm really enjoying hanging out with you guys this morning. Senator Brenner, Representative Tucker, and esteemed members of the Environment and Natural Resources Committee, I'm Jessica Fay, representing the people of House District 66, which is parts of the towns of Casco, Poland, and Raymond. And I'm here introducing LD 960 on behalf of the Department of Environmental Protection, an act to require reporting of perfluoroalkyl and polyfluoroalkyl substances, PFAS, in products and of discharges of firefighting foam containing PFAS. I'm presenting this bill on behalf of the department. While I was not a member of the governor's PFAS task force, I made a point of either attending in person or listening to each meeting. The work the task force did was thorough, organized, and difficult. This bill is, in part, a result of some of that work. PFAS, as you are aware, are toxic chemicals that can cause a host of health problems and can remain in our bodies and environment for very long periods of time. There's not one single solution to the problem they pose. The issue will require a number of actions at both the state and federal level. Thank you for your time, and I'm happy to try to answer any questions.
Any questions from the committee for Representative Fay? All right, thank you for your time and attention. And I believe we will move on to Melanie Loisum. Commissioner Loisum will join us next. Welcome, Commissioner.
Good morning. Senator Brenner, Representative Tucker, and members of the Joint Standing Committee on Environment and Natural Resources. I'm Melanie Loisum, Commissioner of the Department of Environmental Protection, providing this testimony in support of LD 960. The department introduced this legislation last year, but a hearing was not held before the legislature adjourned. This bill is based on recommendations from the governor's PFAS task force, which issued its report in January of 2020. It contains two reporting requirements. One for discharges of aqueous film-forming foam, or AFFF, and for intentional use of PFAS in products sold in Maine. The department will use the information gathered through these reporting requirements to evaluate what limitations may be appropriate and effective to reduce sources of PFAS in our environment. Section 1 of the bill will utilize DEP's existing oil and hazardous materials spill telephone hotline to receive and triage reports of AFFF discharges, in addition to the usual array of reports that are received on that hotline. The department anticipates that current and future users of AFFF that may trigger this requirement would be fire departments, other emergency response teams, and a small number of industrial facilities. The AFFF working group of the PFAS task force worked with the state fire marshal in 2019 to survey all of those entities to inventory their existing stocks of Class B AFFF and provided them with information regarding potential environmental risks of using foam that contains PFAS and the practices for preventing and minimizing releases to the environment. 69 out of 325 entities surveyed reported more than 18,000 gallons of foam in storage. You probably are aware that several states have implemented foam take-back programs where they had funding available, but unfortunately, those efforts have stalled lately due to questions about the environmental effects of disposal by incineration and landfilling. Some states have also adopted prohibitions on the use of PFAS-containing foams, and a variety of legislation is being considered at the federal level. At this time, the department and the PFAS task force only recommends reporting of discharges because Class B AFFF is already being used infrequently in Maine. There are no resources currently to help the fire departments dispose of their stocks, and we are expecting federal action. If the legislature wishes to allocate resources to protecting Mainers from PFAS, I think you've probably heard this from me already, there are plenty of other things for us to spend PFAS money on, so this would not be our first request. However, the department will utilize discharge reports under this law to identify additional locations for PFAS testing and will continue to evaluate if restrictions or other actions are needed. Section 2 of the bill applies to product manufacturers. There are a wide variety of products that are known to contain PFAS and many more that might, but we don't know which PFAS, in what quantities, manufacturers are intentionally adding to their products. This bill would require that information to be reported to DEP and for DEP to make that information available to the public on our website. Maine does have a relatively small population of consumers, but we can use the power of the internet to have a much broader effect. This reporting requirement alone could have a significant effect on future product development due to manufacturers' fear of potential environmental liability in Maine and elsewhere, without the accompanying impacts to Maine businesses and consumers that you often hear about with product prohibitions. This reporting requirement is constructed to be similar to Maine's reporting requirements for toxic chemicals in children's products, so that, like Section 1, the department can leverage existing resources for implementation. The concept of intentionally added is mirrored, for example, after use of that term in Title 38, Section 1691, which has been in place since 2001. This is also the same terminology that is used by the state of Washington and other state reporting programs. We do anticipate some costs for managing a large volume of the reported data and have included a fee provision that also mirrors the Toxic Chemicals in Children's Products program, so that manufacturers who choose to use these chemicals must also bear the cost for making that information public. There are also a lot of potential details to figure out for implementation. I suspect you'll hear some questions about that this morning, which the bill would charge the department with handling through rulemaking. The department recognizes that others presenting today may have helpful suggestions to clarify the requirements in this bill, and we're happy to work on such improvements. Thank you for the opportunity to provide this testimony this morning, and I'm happy to answer your questions.
Thank you, Commissioner. Are there any questions? Senator Bennett has a question.
Thank you, Senator Brenner. Commissioner, regarding Section 2, is that kind of disclosure mirrored in any other states that you're aware of?
I don't know if it's specifically mirrored in this way. For example, there are other states that have reporting and prohibitions on a variety of product types. I'm not sure if there's any state that has a reporting requirement that is quite as broad as this one.
And may I ask, I'm just confused by looking at section 2, and it takes out the title of that section of law and it replaces with something which says information. I'll pull it up myself. It says information designated as confidential. So that's new language that's replacing hazardous waste information on mercury recycle. Why that change?
Senator, hang on, let me get the bill in front of me so I make sure that we're talking about the same area. Are you referring to, yes. So section 2 changes the name of that section because it was specific just to the mercury, chemicals, recyclables. We changed the title of that section based on a recommendation from staff and our attorneys that it just makes it clearer and more appropriately captures the more generic nature of that section.
Okay, it just mentions confidential now in the new title, and it didn't say that at all up above. So,
which is all that section was about anyway. So that's
okay.
Supposed to be helpful to people looking at the statute to understand what it actually covers.
Yes, thank you.
Senator Bennett, or excuse me, Senator Carney.
Thank you, Senator Brenner, and thank you for being here, Commissioner Loisem. I am very excited about part 2 of this bill, and I'm so glad that the department is pursuing it. And I think that's reflected in my question. When do you anticipate that this information would actually be available to consumers? Because I think it's exactly the kind of information we're all looking for when we buy products.
So the reporting requirement would go into effect January 1 of 2023. So we would anticipate as soon as the information is cleaned up enough to be able to make it publicly available, we would do so. So early 2023, as it's incoming, we would be making it available.
Thank you very much.
Any additional questions for Commissioner Loisem? Thanks for joining us this morning. Good to see you.
You too.
Okay, moving on to other folks in the attendee space who are here to speak in favor of LD 960. If you could raise your hand. All right, we'll go in this order. Ms. Woodbury, Mr. Kraus, Mr. Sawyer, Ms. Treat, and Mr. Wade. Welcome back, Ms. Woodbury.
Thank you very much. Thanks again for having me. Once again, I am Sarah Woodbury, and I am the Director of Advocacy for Defend Our Health, formerly known as the Environmental Health Strategy Center, and I'm here to testify in support of LD 706. I'm not going to read my whole testimony because some of it is redundant, but I do want to talk about the fact around disclosure. Most folks know that PFAS are in a variety of products, including food packaging, cooking supplies, clothing, cosmetics, furniture, and firefighting foam. However, in almost all cases, there is no requirement for PFAS to be disclosed, neither to the consumer nor to state or federal regulations. We only know PFAS has been used in many products because independent labs have conducted tests. This makes it difficult as consumers to make better choices and for regulators to understand sources of PFAS. This committee is acutely aware of the problems that have been presented by PFAS contaminated municipal and industrial sludge being land applied, contaminating land, water, and agricultural products. Testing of sludge statewide from small towns to our major cities showed PFAS in excess of the state standards. Septage, which is a non-industrial waste, had levels on average even higher than municipal sludge. In order to address PFAS in sludge, we must understand the sources that are contributing to the sludge. LD 960 would help provide answers by requesting the disclosure of PFAS content. That is a necessary first step in being able to stop PFAS at the source and get it out of our waste stream. However, having the information alone is not enough. It is important that we recognize that in most cases, there is no need for PFAS to actually be used in these products. For most uses of PFAS, there are safer alternatives available. This is the case with firefighting foam, where PFAS-free foams meet the same requirements of PFAS foams widely used by fire departments. Washington State has gotten rid of the use of PFAS, AFFF firefighting foam. Indeed, with the growing realization that the dangers presented by PFAS and the disposable challenges PFAS create, many leading manufacturers are voluntarily reformulating their products without PFAS, and major retailers are refusing to stock products containing PFAS. Keen Shoes announced that they will be eliminating PFAS. Interface and Shaw's, two of the largest manufacturers of carpet, don't make it with PFAS anymore, and home improvement giants Lowe's and Home Depot won't sell carpeting with PFAS. These actions show that the properties imposed by PFAS can acceptably and affordably be accomplished in other ways. Therefore, while we support LD 960's collection of information, this collection should be paired with opportunities to undertake action. There is legislation that will be before this committee this session, introduced by Representative Gramlich, that would follow the lead of this bill and require the reporting, have the reporting fee. It would also require the state to start phasing out currently unavoidable uses of PFAS in consumer products, helping to stop PFAS contamination at the source. Additionally, there will also be legislation before this committee that would help the state move away from the use of AFFF foam, following our friends in states like Washington, Colorado, and our neighbors in New Hampshire that have already ordered an immediate transition to PFAS-free foams. So while we are in support of LD 960, we urge the committee to refrain from making a decision on this bill until the legislation I mentioned can be heard. Thank you for your time.
Thank you, Ms. Woodbury. Are there any questions from the committee? All right, not seeing any. Thanks for joining us. All right, next up, Mr. Sawyer, I believe, is back. I'm sure he's hoping for a solid connection this time.
Thank you, Senator Brenner. I reset my internet and hope this works. Senator Brenner, Representative Tucker, members of the committee, I'm still Brad Sawyer, hopefully with a better internet connection on behalf of the Maine Rural Water Association. Our members urge you to support both initiatives of both parts of LD 960 as they're key pieces in the fight to reduce sources of PFAS in the state of Maine. Requiring companies to notify the state of their products that contain PFAS will benefit people of Maine in multiple ways. As we've discussed before, source reduction is really the ideal way to deal with PFAS, as treatment and remediation are costly and time consuming, and we still don't have great answers as to what the best way is moving forward. We also support the source reduction in firefighting foam that was mentioned. As foam is sprayed, it can often move into groundwater supplies or surface water supplies, and we appreciate that there's a desire to stop that from happening. We also would be happy as an association to work with the firefighting community to better identify these sources of water when they show up on the scene. We recognize that if a life is in danger, that is certainly the number one priority at that current time, and understand that is not something that should be glossed over in any way. But as Ms. Woodbury pointed out, there are ways that we can still have effective firefighting practices while protecting the environment. Given my fear of my internet failing again, I will leave it there and try to answer any questions. To Senator Bennett's question on the previous bill, I did hear it, and we'll bring that information to work session.
Thanks, Mr. Sawyer. Any questions from the committee? Yes, Representative O'Connor.
Yes, thank you, Senator, and thank you, Mr. Sawyer, for being here today. So do you know what the name is of the replacement that Washington, Colorado, and New Hampshire are using for the firefighter foam? And particularly, I think that's pretty important, and I don't really know much about it, so I'd like to read up on it. Thank you.
Thank you, Representative. I do not know the answer, but would be happy to track that down. I imagine some that come after me may have that answer.
That would be lovely. Thank you.
Any additional questions for Mr. Sawyer? All right. Thanks for joining us again.
Thank you.
All right. And Let's see. I believe next up is Sharon Treat. And then Tim Wade. Hello, welcome back.
Thank you very much, Senator Brenner, Representative Tucker, and members of the Environment and Natural Resources Committee. I am Sharon Tree. I live in Hollowell, and I am testifying in support of this legislation on behalf of the Institute for Agriculture and Trade Policy. As I've mentioned before, we've become involved in PFAS contamination issues and have advocated for measures to investigate and remediate PFAS as in the prior legislation. Equally important, however, is to turn off the tap, to stop PFAS at the source and hold manufacturers accountable. One major source of high levels of contamination already in groundwater, drinking water, and soils, both in Maine and nationally, is PFAS in AFFF foam used to fight fires and firefighting training exercises. LD 960 takes a first step in addressing contamination caused by this PFAS containing product, as well as others, by requiring manufacturers to disclose the presence of PFAS in their products and to require reporting of discharges of this contaminant. You cannot prevent contamination and identify potential sources of pollution if you don't know where it is. However, reporting on PFAS isn't enough. We urge the committee to take the next step and to completely phase out use of PFAS in firefighting foam and many other products. With respect to the AFFF foam specifically, Colorado, Minnesota, New Hampshire, New York, and Washington State have all banned PFAS in firefighting foam. Michigan bans the use for training purposes, and this is one of the things that came out in the PFAS task force report, that a great deal of contamination has occurred through training because the same locations are used over and over and over again. And so heavy amounts of this contamination and foam have been deployed to single places that high levels have gotten into groundwater as a result. And I think I did mention that Michigan bans the use for that purpose specifically. And of course, there's several other states that are considering bans. There are viable alternatives that meet international aviation, marine standards, and others that are already on the market. The information I have to go to Representative O'Connor's question is that there are more than 100 fluorine-free foams available from 24 manufacturers, and that's based on 2019 data. So there may be more now. And just also to mention, I do work internationally, and both the European Union, most of the European Union, as well as the United Kingdom, the UK, do not use this foam anymore. We urge the support from the committee of LD 960. We hope you will go beyond the disclosure requirements when the additional legislation comes before you to phase out use of this toxic substance in communities all over the state. Thank you.
Thank you so much. Are there any questions? Representative O'Connor, you have a hand up. Is that a, whoops. Or is it a one hand?
Actually, yes. I just was wondering if someone could answer in the future if those foams for the firefighters that they're using in multiple places, which seems like it could be a good deal, what the cost differential is on that, so I can weigh that. Thank you.
Any additional questions? All right. Thanks for joining us this morning.
Welcome.
Next up is Mr. Wade. Welcome back.
Hi, sorry about that. I was transferring. My name again is Tim Wade, and I am still representing MWEA, the Maine Water Environment Association. And just very briefly, we basically represent wastewater operators, collection system operators, and several vendors and engineers and consultants that work in those systems. I have testified several times in front of your committee as well as the Judicial Committee on numerous PFAS bills, basically singing from the rooftops that we are the receivers of these compounds. I believe this bill is a great first step to holding manufacturers more accountable and alerting utilities of a possible release so that we're better equipped to handle that when it comes our way. PFAS has become a term that we are now all very well aware of. The chemical's negative influence with our environment and on human health has been dramatic. You guys have heard this already. PFAS are man-made compound that were introduced sometime in the late 30s, early 40s, and have been used in all sorts of different materials, including food packaging materials, household products, water repellent materials, non-stick products, and firefighting foam. Most recently, many manufacturers have stopped using PFAS compounds here in the US. We feel this bill will help our members and public utilities to avert additional contamination to our drinking water supplies, wastewater systems, and stormwater systems through two key factors. One, the direct notification to the Department of Environmental Protection in the case of a release, and two, a better overall public understanding of the products that they are using. As PFAS contamination has become a common report in the daily news, we believe that the public will be far less likely to knowingly use products containing these compounds. The requirement to report a product contains PFAS compounds should be a very effective deterrent to their use. In the event of a release, typically through the use of firefighting foam by a municipal or private fire department, notification to DEP would result in a streamlined notification to any affected utility. This practice is already utilized voluntarily by some fire departments in the DEP for the release of any contaminant to a wastewater or stormwater system. An immediate report issued about the use of PFAS to our member utilities allows those utilities to take appropriate action to minimize any impact it may have on our water supplies, wastewater, or stormwater systems. I have witnessed the effectiveness of this streamlined response excuse me, as developed over the past several years involving the Greater Augusta Utility District System, which I work at. In 2011, we were not notified of the spill directly adjacent to one of our drinking water supply wells until responders were already on site, and one of our own trustees happened to drive by and notice the melee near one of our wells. After that, we engaged all the responders and discussed the importance of our response being coordinated as well as the DEP and the fire and so on. In subsequent years, we have received calls from Augusta Fire and/or Maine DEP for any spill adjacent to any of our systems, and it's worked wonderfully. We probably average, I would say, maybe 2 to 3 calls a month, anything from a home heating oil spill near our system to a vehicle accident where fuel or coolant has been released, to still, like in 2011, a large truck that overturned and spilled part of its load either into a stormwater or wastewater system. In conclusion, this bill helps to ensure that public and the system's operators have the information needed to make well-informed choices or responses to help protect public and environmental health. I strongly urge the Environment and Natural Resource Committee vote ought to pass on LD 960. Thank you.
Thank you, Mr. Wade. Are there any questions from the committee? Yes, Representative O'Connor.
Thank you, Senator. Thank you, Mr. Wade. So you said that a lot of manufacturers are voluntarily getting rid of this product, which is excellent. That's a great thing. Do you know which manufacturers still continue to produce this product? And if you don't, could somebody out there maybe could answer that or bring that information to the work session would be wonderful.
I will work on getting that information. I do have maybe a partial answer to your last question. In working with Augusta Fire Department on a vehicle fire February of last year, there was AFFF foam was used in fighting that fire, and we had to do in conjunction with the fire department. First and foremost, the response was to contain the foam, which was directly adjacent to a stormwater system. But in follow-up, we reached out to the manufacturers and received some information off of their SDS or their safety data sheets, which any chemical is required to have. They don't specifically list exactly what's used in the proprietary blend for any of the PFAS compounds. However, I was told that there are two different types with this particular brand, which was Fire Aid 2000. And the two types, a C8 foam and a C6 foam. The C8 foam was tested to a detection limit of 80 parts per billion, and there was no detection in the C8 foam. 80 parts per billion, however, is a much higher number than any number that has been discussed as a limit for PFAS.
Thank you.
Water, so.
Thank you. That's pretty interesting. Thank you very much.
Maybe it's helpful for the committee, but C8 is another, it's 8 chains of carbon and 1 fluorine. Carbon, fluorine. Okay, any more questions for Mr. Wade? All right, not seeing any. Anyone else in the attendee space here to speak in favor of the legislation at hand? Roger Kraus. Welcome, Mr. Kraus.
Good morning, Senator Brenner, Representative Tucker, members of the Committee on Environmental and Natural Resources. My name is Roger Kraus. I'm the General Manager of the Kennebec Water District in Waterville. And I'm here today representing the Maine Water Utilities Association in support of LD 960. I'd like to thank the department and Representative Fay for putting this bill forward. The Maine Water Utilities Association was formed in 1925 and we currently represent 109 water utilities. Our testimony today is focused on the discharge of AFFF firefighting foam and the reporting requirements there. As has been alluded to in other testimony, public water supplies, public water systems use both groundwater and surface water for supplies of drinking water. And the discharge of firefighting foam into the environment is likely to end up in the groundwater and or surface water. Unfortunately, our utilities don't have the luxury of having supplies that are protected, completely protected from human development. There's roads, there's housing, there's railroads that pass through these surface water protection areas, these sources, these watersheds, and consequently firefighting may be needed at times. So the use of this reporting mechanism to let the department know about any discharges will be a benefit to utilities, to let us know if there is any kind of discharge of firefighting foam containing PFAS in our areas of supply. So everything runs downhill, everything runs to the water, to the groundwater or to the surface water. So anything we can do to be alerted to a discharge is to our benefit. So we ask the committee to support LD 960. And happy to take any questions.
Any questions for Mr. Kraus from the committee? All right, not seeing any. Thank you for joining us.
Thank you.
All right, anyone else in the attendee space here to speak in favor of the legislation? Anyone here to speak in opposition? All right, Mr. Straub. Come on over.
Thank you. Senator Brenner and Representative Tucker and distinguished members of the committee. I'm Patrick Strout from Exeter, Maine again. I'm speaking in opposition to this because I've lost all ability to finesse my testimony on Zoom. But I think the council is in principle supportive supportive of reporting on the presence of certain PFAS compounds used in the manufacturing process. But we have several questions about the language proposed in sections 2 and 3 of the bill. So I think we're signaling that we need more discussion, and would be glad to work with the department with regard to that. And I can give you some examples of some of the challenges from the manufacturer's perspective on these issues. We did participate in the PFAS task force, and we appreciate the approach of gathering information before we jump to making more solid policy decisions. We think that's a great approach. There are a series of questions generated by the language that I thought I'd just illustrate. One of the challenges manufacturers are experiencing is that purchased additives not regulated by the federal government for certain content, but subject to a variety of state disclosure provisions, lack a uniform interpretation. For example, a vendor in one state delivered materials claiming no chemicals of concern were in the formulation, but the sending state's criteria for reporting had a de minimis definition at the parts per million level. So this is going to be a little bit of a challenge for us to make sure we are measuring the right things and at the right levels. But again, the absence of standards universally will make it a challenge for some of our manufacturers, but that's something we can talk about. We've also included every PFAS under the sun, one fluorinated carbon atom, and there are some methodologies for testing that have not yet been derived. So I think we're going to have to talk about the span of the PFAS chemicals we're looking at. An additional challenge that we hadn't really thought about in reporting these guidelines is illustrated by the insecticide treatment over about 2 million acres in eastern Massachusetts. Traces of PFAS were found on the ground that weren't linked to the pesticide, but were linked to the container. So fluorinated plastic containers can be the source of some residuals. And so I asked the question, should we be certifying containers as well? It's just an indication of how some of these compounds are somewhat complicated. And what we're talking about is a chain of custody sort of definition. Main manufacturers are often making products that are sold to national manufacturers located out of state. So this is the other kind of challenge that I think we've got to work at. Are these products to be included in the inventory of final products? But there needs to be more discussion. And again, this is that chain of custody approach. At what point are we reporting, and who has, at what point is that responsibility incurred? So those are some of the examples of the challenges that we're more than willing to talk through. There are some terms, including the degradation of byproducts in the PFAS definitions. If those occur, how do we know about it? And we have some questions about how this bill is referenced in terms of some exemption for reductions if you're part of the Reductions in Toxins Packaging Act. And we'd like the chance to talk to the department more about that as well. Some materials may fall under that provision, but is it truly an exempt provision? So I've raised questions. We're more than willing to speak with the department and work towards some kind of reporting mechanism that's got reasonable objectives. So thank you very much.
Thank you. Any questions from the committee? I have a question for you. I'm just curious if you could maybe give me some examples of when your members are using products with PFAS in them.
Well, we know in the past that it was an important component in waterproofing containers made of paper. So it's like in your Gore-Tex jackets that supposedly have PFAS. Some dog food bags had PFAS in them, and it is the product that allows us to move from plastic into paper packaging. But now we've got to think about whether there's PFAS in those containers, because you would have, it resists oil and moisture, so it makes products dry and preserves them. So that might be one example of where it's occurring.
Thank you. Any additional questions? All right, thanks for joining us this morning.
All right, thank you.
Anybody else here to speak in opposition to the legislation at hand? Anybody here to speak neither for nor against? So Laurel Shader and then Neil Goldberg. Welcome. Whoops, you're on mute.
Hi, good morning, Senator Brenner, Representative Tucker, and members of the committee. Thank you to the Maine Legislature's Committee on Environment and Natural Resources for providing this opportunity for public comment. My name is Laurel Shader. I'm a senior scientist at Silent Spring Institute, a nonprofit independent research organization. Since 2009, my research has focused on PFAS exposures from drinking water, food packaging, and consumer products. I lead 2 PFAS-related health studies, one of which is part of a national multi-site study funded and coordinated by CDC. I'm also part of the STEEP Superfund research program led by the University of Rhode Island in collaboration with Harvard and Silent Spring Institute. As you consider this legislation, I'd like to share some key points based on my own research and on other published scientific studies. My first point is that PFAS are common in many everyday products, as we've heard, even when they're not critical or can be substituted. A 2020 study by researchers in Europe and the US documented over 200 uses of PFAS. They're in everything from microwave popcorn bags and dental floss to carpets and paints. They're even in guitar strings and climbing ropes. PFAS can migrate out of products and end up in our bodies, contributing to widespread exposure in the general population. PFAS can also pollute communities where they are manufactured, and after products are thrown away, PFAS can enter the environment through landfill leachate and land application of biosolids from wastewater treatment plants. A 2019 research study developed a framework to evaluate the essentiality of the many uses of PFAS on the global market. According to this framework, many current uses of PFAS are considered non-essential, meaning that they are not critical for health, safety, and function. Other uses, such as AFFF firefighting foams, can be avoided by substituting with similar products, such as fluorine-free foams that don't contain PFAS but serve the same function. My second point is that we need class-based solutions to phase out non-essential uses of PFAS. According to the EPA, there are over 9,000 PFAS compounds, which means it's simply not possible to evaluate the toxicity of each one individually. The American Public Health Association and a growing number of expert scientists have recommended approaching PFAS as a class and reducing overall PFAS exposures by eliminating non-essential uses. My third point is that disclosing the uses of PFAS will create better transparency to inform decision-making. It is often difficult and sometimes impossible to figure out which products contain PFAS. Disclosing information about the uses of PFAS in products will inform decisions by consumers, retailers, and businesses seeking to avoid products with PFAS. This information could also be used to identify geographical areas where PFAS have been used by businesses and industries. I'll end by saying that PFAS are frequently detected in drinking water, and PFAS-containing firefighting foam is often a source. Widespread PFAS exposures are concerning in light of scientific studies that have linked PFAS to a wide range of health effects, including newer PFAS chemicals currently being added to products. Thank you for this opportunity to provide comment.
Thank you for joining us. Senator Bennett has a question for you.
Thank you, Madam Chair. Ms. Shader, thanks so much for coming to testify today. You know, we're getting very close to the 60th anniversary of the writing of the publishing of Silent Spring. And I just have to ask, 60 years, why are we here talking about PFAS and what is next? I mean, what's wrong? It's a serious question. What is wrong with our polity or our systems in this country where we continually commit the same error where we're injecting pollutants and toxic chemicals afresh into our systems.
Well, you're absolutely right, Senator. We haven't really learned the lessons. We've dealt with PCBs and chlorinated flame retardants, and PFAS are just the next chapter in that same book. A major problem is that chemicals are put into production before they're adequately tested for safety. And when problems are identified, we simply swap out one problematic chemical for another one that we often don't know much about. This has happened with bisphenol A. You can buy BPA-free baby bottles and baby products, and instead, these products have other bisphenols like BPS. And when you swap out one chemical for another that serves the same role in a product, it often can have similar toxicity. That's one of the reasons with PFAS why it's important to consider them as a class and not just try to swap out short chain for long chain or within the family, because as a class, they all raise concerns because of the persistence of those carbon fluorine bonds and their mobility in the environment and the ability of some of them to accumulate. So tackling them as a class is essential because we simply can't address the challenges with them one at a time. So at a national level, I think that we need more testing of chemicals before they go into production and widespread use. Europe does a better job of this than we do here in the US. But in the meantime, having information about which products contain problematic chemicals does allow for more informed choices.
If I just may follow up, is we have the FDA that tests medicines and drugs extensively, or it doesn't test them, but requires review by the people that are wishing to sell these products. And yet we have these very complex chemicals that we just rush, or we don't rush, manufacturers rush into the market. And then it seems that maybe the penalties are not high enough for, they just pay, they take a right down to a few $1 billion 20 years later, and that's the way of it. I just wonder, do you have any recommendations for systemic changes that rather than just have us sitting here in the legislature, 60 years after the writing of Silent Spring, dealing with another set of these issues? What's the systemic fix?
Well, I share your frustrations. I'll note that I'm a scientist and not a policymaker, so I find the challenges.
All the better.
As I said, I think that we need to do a better job of testing chemicals for safety ahead of time. The FDA, and in my written testimony, I have some more details. The FDA did recently take back its approval for certain PFAS chemicals, some of these short chain PFAS that are used as replacements based on research by their own scientists at FDA. So that's a step in the right direction. It'll take several years before that actually goes into effect. And it feels like it's always reactive to information rather than being proactive and doing more adequate testing ahead of time.
Thank you.
Thanks for your questions.
Dr. Shader, I have a question along the same lines. Can you talk a little bit about what the process of allowing chemical companies to self-regulate does that allows this to be perpetuated, one dangerous chemical after another being put into production and into our consumer products?
Well, often chemicals undergo pretty rapid screening by the EPA, and some things are an exception. So pesticides, pharmaceuticals do undergo quite a bit of scrutiny before they're used, but consumer product chemicals don't undergo that same level of scrutiny. And it's usually after the fact, once chemicals are considered high production volume chemicals, after they're widely out in the environment, after people are exposed to them, and we have a body of information linking them to harmful health effects, that then we look backwards and decide that maybe we should use fewer of them. And that really seems backwards. In order to take a precautionary public health strategy, we really need to do more testing of chemicals ahead of time. And, innocent until proven guilty is good for the judicial system, but I would say not for chemical regulation policy.
And in your experience thinking about and researching the class of chemicals, the PFAS class of chemicals, what would you offer as like an essential use? Is there any product that we definitely need to have this class of chemicals be a part of?
Sure, and in my testimony, I linked to the paper that came out in 2019 that went through the 3 classes. And for instance, there are medical devices that contain PFAS that are currently considered essential because they play a life-saving role and there currently isn't a substitute. I believe that certain occupational protective equipment might fall under that same heading. The paper by Ian Cousins and others makes the point that it's not the chemical that's essential, it's the use. So it leaves the door open that in the future a substitute could be found. But the paper makes the case, and I would agree that in most cases that the uses are substitutable or non-essential.
And I'm not sure if you're the right person to ask this question to or not, but in terms of the use of something like firefighting foam, what happens for firefighters that work with that product? What kinds of worker safety precautions are in place, or disclaimers that they need to sign in order to be able to use it, or training? What happens on the ground there?
I have to say I'm probably not the right person to answer that specific question. Firefighters can be exposed in multiple ways. Certainly the AFFF is one concern. The turnout gear that also protects them can have protective layers that contain PFAS as well. And then when they're actually fighting fires, those fumes can contain chemicals from the products in homes. So they can be exposed in multiple ways. Certainly there's a lot of attention being paid now, rightly so, to exposures to chemicals among firefighters in light of growing evidence of higher cancer rates. In terms of training practices, I'm sorry, I'm not the best person to answer that question. But there are some, common sense kinds of approaches, for instance, washing down turnout gear after fires that can reduce their exposures. But I can't say specifically about, training practices.
Thanks, appreciate it. Are there any additional questions for Dr. Shader? All right, thanks for joining us.
Thank you.
Okay, let's go back to our little, all right, it looks like we have Mr. Goldberg here to speak neither for nor against. If there's anyone else over in that space that's here to speak about this piece of legislation, neither for nor against, for or against, if you could raise your hand. Uh-oh, did we lose him? Oh, no, here he comes. Welcome back, Mr. Goldberg.
Thank you. Bringing up the rear today. My name is Neil Goldberg, Senator Brenner, Representative Tucker, and members of the Environment and Natural Resource Committee. I am providing testimony neither for nor against LD 960 on behalf of MMA's Legislative Policy Committee. In general, the association fully supports reporting requirements of manufacturers or of products with intentionally added PFAS substances. Again, as we were talking about earlier, the state needs to know where there's PFAS contamination, and then prior to that, where there are products that are being used with PFAS intentionally added to it. However, there is some concern specifically with regard to municipal fire departments and what those reporting requirements would mean to them. Currently, most fire departments are primarily volunteer-based, and adding this reporting requirement could be time-consuming and costly to them. And so just making sure that there's not a particularly difficult or complex process for them to report this to DEP. And this is a practice that they're primarily already doing for their own safety and record. We just want to make sure it doesn't become too convoluted. There's also concern that that reporting requirement on the manufacturer's end could create a price increase, which would then be passed down to municipalities. And so for that regard, as was previously mentioned, it might be more appropriate to find alternative firefighting agents, although that's also proved to be quite difficult. To address a question earlier, there are fluorine-free firefighting agents, foam agents like this, but some of them have been shown to actually break down back into PFAS. And so although they may not start like that, we're still finding contamination later, which then leads to the kind of final concern in municipalities, which was these reporting requirements. As there's more reporting, invariably there's going to be more identification of PFAS contamination and who is responsible for that, both testing as well as cleanup. one firefighter, fire department in one municipality might impact another, and ultimately, where does that mitigation end? And so, although we're largely in support of this, we just do have some concern about the impact of local government functions. Thank you for your time, and I'm happy to address any questions.
Thank you. Any questions for Mr. Goldberg? All right. Not seeing any. We thank you for your time. And one last call for folks here to speak neither for nor against, or in favor or in opposition to the bill at hand. Okay. And with that, I believe that we will take a quick 30-minute break so folks can refresh, and then we'll come back and hear our last two bills when we get back. So it's 12:23 now, so that'll bring us back 7 minutes before 1 o'clock. What are you laughing at, Senator Bennett?
Very, very precise.
Well, when you're a nurse, you have to be able to look at the clock and tell the time really quick.
I appreciate it. I do.
Okay.
I'm happy. That's why I laugh.
Okay. All right, everyone. We'll see you at 7 minutes before 1 o'clock. Thank you.
Nice flower.
Why, thank you. We just started cutting flowers out of our greenhouses, so today's the day. Everybody ready? We have we'll go ahead and get started. Okay, we're going to open up a public hearing for LD 802, an act to ensure decommissioning of solar energy developments. And I believe Senator Black is here to introduce LD 802. Good morning, Senator Black. Whoop.
Good morning.
How
Well,
are things at your farm today?
Good afternoon.
Oh, you're right, it is afternoon. How are things at your farm today?
Well, good. I had sap tanks running over this morning, so I've been busy.
Good, good. Delicious. Thank you for joining us this afternoon.
Thank you for allowing me to. You ready for me to start? Good afternoon, Senator Brenner, Representative Tucker, and members of the Committee on Environmental and Natural Resources. I am Senator Black. I represent Senate District 17, which is all of Franklin County and 4 towns in Kennebec. It runs from just north of the Augusta Civic Center all the way to the Canadian border and Coban-Goa. So it's a good sized district. I am here to present LD 802, an act to ensure decommissioning of solar developments. I am presenting 803, LD 802 for the department, and because of the rapid expansion of solar sites on prime farmland. We'll try to keep this testimony short because I know the experts that will follow will give you all the details. In 2020, Maine permitted 150 solar projects across the state, and Maine is on track to permit even more this year. Nearly all of these projects are on undeveloped lands, and the projects approved in 2020 cover over 4,000 acres. Currently, there is no plan for when it comes to the decommissioning of these projects, which could lead to state or local communities having to pick up the cost to do so. This bill requires owners of solar projects to remove the panels and restore the site after the useful life of the project is over. Such as on existing farmland, decommission must be sufficient to support the resumption of farming or agricultural activities. This bill also ensures that the developers fund decommissions of these projects, so towns and states are not left holding the bill. As a farmer and a woodland owner, I want to make sure that the land that we have been left stewards of returns to what it was before, and that we take care of it. Thank you, and I would answer any question that you might have, but I think there'll be other people from the department that can answer them better than I can.
Thank you, Senator. Are there any questions for Senator Black? All right, I don't see any. And let's see, Mr. Crawford and Mr. Livesay are here from the department. And I think it's Mr. Crawford. No, wait a minute. It's Mr. Livesay for this one. Did we lose him? Oh, there he is. Welcome. Good afternoon.
Good afternoon. Thank you very much. Senator Brenner, Representative Tucker, and committee members, I'm Nick Livesay, the Director of the Bureau of Land Resources at the Department of Environmental Protection, and I'm here today to speak in support of LD 802. The Senator Black indicated Maine's making great strides to achieve its renewable energy goals, and no place is this more evident than the recent increase in solar energy development. Last year, the department approved over 150 solar projects. That compares to about a half dozen the prior year. And these have the cumulative capacity to produce nearly 900 megawatts of renewable energy. Solar energy development is a relatively low impact form of development, but has a sizable footprint. The projects approved just last year occupy more than 4,000 acres. And through the first quarter of this year, the department has approved or has under review more than 65 projects. And these ones would occupy nearly 2,000 acres. And I don't expect the application flow to stop with the 65 that are already in the door. What will happen to these solar projects after their useful life? LD 802 is intended to answer this question and ensure that solar projects are decommissioned. This means that the panels, the racking systems, and other infrastructure are removed and the site restored. This is environmentally responsible and consistent with good solar industry practice. Presently, the department has the ability to require decommissioning for larger projects permitted under the site location of development law. These are projects that occupy more than 20 acres, and that 20 acres is one of the thresholds for getting into site law. For projects under this threshold, the department lacks the authority to require decommissioning. In 2020, the overwhelming majority of projects approved by the department, roughly 80%, were below this threshold. And a significant portion of those were between 18 and 20 acres. The department believes projects under 20 acres should be decommissioned as well. To achieve this objective, LD 802 requires developers of solar projects occupying 3 or more acres to establish and ultimately implement a decommissioning plan, requires that the developers provide financial assurance that they can implement the plan, and assigns responsibility for reviewing and approving decommissioning plans to the department, and for smaller projects in the unorganized parts of Maine to the Land Use Planning Commission. This decommissioning requirement would go into effect for new projects on which construction begins on or after October 1st of this year, and would also apply to existing projects sold to a new owner after the same date. In closing, the department is encouraged by the interest in renewable energy development in Maine and seeks to ensure this development is constructed and through LD 802 ultimately decommissioned in an environmentally responsible manner. Thank you for the opportunity to testify, and I'm happy to answer any questions you have now or at work session.
Thank you, Mr. Livesey. I have a question for you. I really appreciate and applaud the efforts to consider the future sort of end cycle of where these solar projects will end up. I have a couple of questions. I'm wondering if you can give me a sense of the useful life, of how many years you're envisioning these projects to last?
I think 20, 30 years, so for quite a long time.
And the financial assurance that you're looking for from the solar developer, how is that determined, and what is the where is the assurance that they'll still be around in 20 or 30 years?
So the way the bill is structured now, and this is consistent with how we're handling the site law projects, where we're requiring as a condition of approval that they deal with decommissioning it. And that mirrors a little bit how we handle wind. A developer has to have a plan for how they're going to basically remove the panels and restore the site. And so that kind of outlines the work that needs to be done. And then a price tag can be roughly assigned to that. And the way the bill is currently structured, the price tag, if you will, needs to be evaluated every 5 years. Because as you can imagine, the cost of taking a site down today is going to be less than it is in the future. And I guess the rationale for the 5-year increment is that although these projects are designed to operate for, let's say, 30 years, if they stop operating sometime between development and that 30-year cycle, we would expect, pursuant to this bill, that they be actually taken down. And so the financial assurance, the most common form that we see for solar projects is a bond.
Okay. And I'm assuming these are not concrete foundations, but they're ground screws, usually?
Yeah, most what we're seeing are posts. Yeah, so I think they probably just pile drive in the ground. I haven't been to watch one constructed, but the footprint, the actual sort of impervious area, the footprint of these solar projects is really very, very limited. It's basically the road really is if there's a new road that's needed is where sort of your impervious area comes in. And then where these projects are being sited typically are in undeveloped areas, whether it's agricultural fields or some sort of field or woodland. And a grass area is maintained below the solar panels to help manage the stormwater flow.
Great, thank you. Representative Dudera has a question.
Thank you very much, Senator Brenner. Mr. Livesay, the bill seems to talk about people doing this, but would this also apply for municipalities or community solar groups? Would they also have to do this decommissioning plan? Thanks.
So the way that this is structured presently, the trigger for needing to plan for decommissioning is the size of the project. And so there isn't in here drafted an exemption for, say, a municipality that would own and operate, for instance, a solar project. But that's something that certainly could be considered.
Well, excuse me, may I follow up?
Yes,
okay,
please.
Thank you. So I agree, I hear what you're saying. It has to do with the size of it, but depending on if they fit the size requirements, is a group like a municipality or a community solar project group, a nonprofit, say, or are they also included? It's not just developers. It could also be a municipality.
Presently, yes.
Okay, thanks.
Representative Hanley?
Yes, thank you, Madam Chair. Thank you, Mr. Livesay, for your testimony. I have a couple of questions. First one being, how come we're stopping at 3 acres? 3 acres is a considerable amount of property. Why not go to an acre or something like that? Anyone discuss that?
Certainly, we had some discussion internally about what the appropriate size range would be. And one of the things that we were trying to not capture here, and there may be other ways of doing this, is a set of solar panels that are put up, for example, at a farm to provide energy just for that farm, as opposed to what I consider a commercial type operation, whether it's distributed generation of the projects under 5 megawatts. And so if you look at 5 megawatts takes up 20 acres, 18 to 20 acres typically. We sort of scaled it down, and that's where we landed on the threshold size, but it certainly could be adjusted upwards or downwards.
Yes, thank you. Follow up, if I may.
Yes, please.
Is there any consideration for the waste of the solar panels themselves? What are they going to be part of this decommissioning?
I'm turning up my volume here if I get close to you. There's nothing in this bill that deals with how I guess a used or no longer functional solar panel would work, or how it would be disposed of. I would imagine that the existing solid waste management laws would govern how one handles and where one sort of disposes of the used panels. This particular bill is focused on, I guess I'll call it the siting aspect of solar. And so that is after the life of the project, what happens to that site? And then as far as where the materials go that are removed from that site, that would be in accordance with the existing solid waste management laws, and the individual constituents and components of those panels will drive where and how those panels are handled and disposed of.
One more, if I may, Ms. Chair.
Yeah, go right ahead.
If under current law, what would prevent a solar facility from simply stacking panels in 50 stack piles and leaving them? Is there anything that would forbid that?
I think there is, and so we're straying a little bit outside of my wheelhouse, but the definition of solid waste, it has to, there's a component, as I recall, and if I really make a mistake here, hopefully somebody is listening and they can tell me that, and then I can correct it for you. But I believe the definition of solid waste does get into sort of a product being not just reused, but used. So once you take something that was a solar panel and you stack a whole bunch of them over on the back 40, now you're basically disposing of a solid waste as opposed to operating a solar project. So you can't do that under existing law. And we're not trying to get at that sort of possibility here, I guess, or come up with a new regulatory system for disposal of solar panels.
Okay, if it's possible, could you get that answer for us for the work session?
Sure, I'm happy to do that, and I'm fairly sure that once these things are no longer functioning, if you stick them somewhere, it's a waste, and you're on the hook for managing them accordingly. I'll verify that for you.
Thank you.
Representative Ziegler.
Thank you, Senator, and thank you, Mr. Lipset, for being here today. Just two quick questions. Are you aware of France and that they have they have to have their solar panels to be recycled before they can have a project going? Is that applicable for a model?
I'm not aware of that or any of the laws in France for that matter. So just if you're a new development, are you saying that they have in place a requirement that you have a sort of recycling plan for the back end?
Yes, I follow all the laws in France very, very astutely. Supposedly that's what I read. And what they're trying to do is deal with the issue in the 20 to 30 year range of life. Of course, we also have laws that dismantle coal plants and natural gas plants. At the same time, my other question is, in the permitting, what decides the actual footprint? There was some confusion. I was talking to some people this weekend and they were saying that it's not the panel, but the footing. So what does, where do you get the size of the solar?
Yeah, sure. So that's an important question, obviously, and it matters for jurisdictional purposes because it's a project that occupies more than 20 acres that gets you into site law. And so what we look at are certainly the panels. And if you have a fence around your project, that would be included in your calculation toward the 20 acre threshold. And then also areas that you might maintain in a cleared state for shade management. So one of the things that we'll commonly see is you'll have, sort of the obvious footprint of your solar development, but then there'll be a clearing of forested area so that the sun can hit the panels. And that area, it won't be stumped or grubbed, but it will be, they'll cut the trees and then obviously have to periodically make sure that there's not sort of resprouting that would get in the way of the sun. And then also the connection to the three-phase power is where our substation, that would count within your 20 acres as well. Most of the projects that we're seeing now, and I think this is largely driven by economics, are sited in close proximity to transmission or distribution lines, three-phase power.
Thank you.
Are there any additional questions from the committee for Senator Bennett?
Thank you, Madam Chair. Mr. Livesey, why would you even entertain differing view toward this legislation depending on the corporate form of the developer?
Well, we haven't done that here, and I'm open to hearing why that might be. If a municipality, for instance, owned it, and they might have a different form, I guess I'm not endorsing anything different than what we have in the bill at this time. I'm open to considering it. And one of the things that would come to mind is, let's say you have a municipality that owns a solar project. Municipalities are different than an LLC, for example, in that they do have the ability to raise revenue if they need to remove a project in a way that an LLC, if they don't, say, post a bond on the front end, they may have no money by the time it comes time to decommission, depending on how money's been moved around the corporate structure. So maybe there are differences there that are material from a policy perspective, and maybe they aren't. I'd want to think them through, but that's sort of my off the top of my head thinking at this juncture.
All right, it just seems to me to be kind of strange point to introduce in the bill. I think the way you've written it makes more sense than to start carving out exceptions for one class of an entity versus another. Thank you.
All right. Any more questions for Mr. Livesay from the committee? All right. Thanks for joining us.
You're welcome.
And are there any folks in the attendee space here to speak in favor of the legislation? If you could raise your hand. All right, we'll bring Mr. Wood in next. Welcome, Mr. Wood. Thanks for joining us.
Thanks for having me, Senator Brenner and Representative Tucker and members of the ENR committee. It's good to see you this afternoon. My name is Rob Wood. I'm the Director of Government Relations and Climate Policy for the Nature Conservancy in Maine. Here to speak in support of LD 802, and we thank the department for bringing forward this important bill. So the Nature Conservancy supports the rapid deployment of well-sited clean energy to reduce greenhouse gas emissions and address climate change, while at the same time continuing to protect the lands and waters that are so important to Maine's people and wildlife. As policymakers and state agencies develop and implement strategies to encourage low-impact clean energy development, LD 802 addresses a key piece of the puzzle, which is decommissioning. Selecting good sites for solar development on the front end is critical, but a decommissioning plan ensures that regardless of where a ground-mounted solar array is located, there's a plan and financial resources in place to reclaim the location if the array is no longer in productive use in the future. We think this is a common sense approach. It has precedent in Maine's existing laws and regulations. The requirements for decommissioning also reflect the reality that solar panels do have a finite lifespan. At the end of a solar array's life, it may be retrofitted with new panels and continue in productive use, which LD 802 would allow for. However, this bill will ensure that if an array does not continue in productive use, it will be removed and the site revegetated, or if applicable, restored to farmland. TNC respectfully suggests one small amendment to LD 802 for the committee's consideration. We would just suggest that in the definition of decommissioning, adding the word fences to the list of components of a solar energy development. We think that word may already be captured in the including but not limited to language in the definition, but we think it could be useful to add the word because if a solar array is decommissioned but its fence is left in place, it could still kind of create an impact on the connectivity of the wildlife habitat in the area. So again, we strongly support the bill, and we thank the department for bringing it forward, and thanks for the opportunity to testify. I'd be happy to answer any questions.
Thank you, Mr. Wood. Any questions from the committee? Senator Bennett.
Thank you, Madam Chair. Mr. Wood, what's the magic about 3 acres as far as you're concerned?
Thanks, Senator Bennett. It's a great question. I don't have a great answer to that question. I would certainly defer to the department in that regard.
I just always wonder these things as to, you know, who gets excluded and who gets included. How many projects are we talking about that would be excluded? Those sorts of things. When you start doing these limits, that's just, you know, it just seems. And furthermore, it would seem sensible for maybe for our own research staff, but anybody else who cares about this bill, to look at other states and see what they're doing and what makes sense and what their experience has been, rather than try to reinvent the wheel on these sorts of technical questions. Thank you.
It's a good point. And I will note that I think, and others in the solar industry could certainly speak to this better than I can, but, in terms of how much, how many kilowatt hours or megawatt hours, you're expected to get per acre of land area, a 3 acre area would get you about, a little more than half of a megawatt, I believe, of a solar array, which is, typically around where you might kind of see a behind the meter solar installation for to offset the energy use on site, as Mr. Livesay had suggested. And so once you get kind of beyond that, you're looking at more of the kind of community solar, bigger solar arrays, of commercial scale solar arrays. And so I do think we have seen most of those commercial scale distributed solar arrays, at least in Maine, bumping up against that 20 acre threshold, and that's really where most of the development's occurring right now.
Thank you.
Sure.
Any additional questions? All right, thank you, Mr. Wood, for joining us.
Thanks for your time.
All right, anyone else to speak in favor of the legislation in the attendee space? Anyone here to speak in opposition to the legislation? Anyone here to speak neither for nor against? Mr. Payne. Welcome, Mr. Payne.
Thank you. Senator Brenner, Representative Tucker, members of the committee, my name is Jeremy Payne. I'm the Executive Director of the Maine Renewable Energy Association. Our members sustainably manufacture clean electricity from hydro, biomass, wind, tidal, and of course, solar. So I'm here to testify neither for nor against, although candidly, we very easily could have been in the support category with just some suggestions. I just chose neither for nor against because we did have some ideas for your consideration. And I did have a chance to speak with Mr. Livesay last week and shared this feedback with him. So I will do so with you as well now. So as drafted, 802 could create two different sets of decommissioning standards, one from the state and one from the town. So you might want to consider whichever is more stringent standard so that you're not asking whether it's a developer or a municipality to abide by two different sets of standards that could potentially conflict with one another. And then the conversation around the drilling and the bedrock is an interesting one. It talks about requiring decommissioning to a depth of 48 inches. Some of the posts are drilled directly into bedrock, so we would suggest that it might make more sense to actually just cut them off at the bedrock level, because otherwise you may actually have to do blasting to get down to the bedrock level to pull absolutely everything out. And that same section, section 3 in the same area requires the land to be revegetated and regraded. And you might want to consider including some flexibility, as the landowner might not want to return everything exactly the way it was. So for example, oftentimes the access roads provide them access to other areas of their land that they have not had previously. So something like a provision that says unless otherwise required by the landowner and approved by the permitting authority, you may be able to address that issue as well. And in terms of financial equity, you should give consideration to making the municipality a co-payee for the financial assurance or bonding process, so the DEP and the host community are on equal footing. And then just the last thing, and this is more observational than something we think is critical. Mr. Livesay mentioned that the decommissioning plan is required to be updated every 5 years, as is currently done for a lot of the grid scale wind projects. There's not that many grid scale wind projects in the state, but it's been our understanding this has been a very time consuming process for staff. And we have, as you heard Mr. Livesay say, literally dozens of projects that were approved last year, dozens more that will probably be approved this year and then the next year. I think we just want to make sure that we're not creating an amount of work that we can't possibly accomplish. So if you can achieve the same goal by making sure that there's the right amount of money in the pot to be accessed if you need it, without requiring it to be done every 5 years, that might be something that gets you to the same point with fewer staffing resources required. So with that, I'd be happy to answer any of the questions you may have.
Does the committee have any questions for Mr. Payne? All right, thank you for joining us. All right, anybody left in the attendee space here to speak on LD 802? All right, and with that, I believe we can close the hearing on LD 802. Thank you so much, Senator Black, for bringing this legislation forward. We look forward to the work session.
Thank you.
And now we will open up a public hearing for LD 872, an act concerning motor vehicle emissions control system tampering. And I believe our own Senator Ziegler will be here to introduce this piece of legislation.
Thank you very much, but I never wanted to be a senator.
I'm sorry.
And I won't tell you why.
Representative Ziegler, please, my apologies.
They're accepted. Senator Brenner, Representative Tucker, and fellow members of the Joint Standing Committee on Environment and Natural Resources. I'm Representative Stanley Page Ziegler, and there's a typo in there just in case. I know all you read my testimony. And I represent House District 96, which includes Montville, Liberty, Lincolnville, Belmont, Montville, Morrill, Palermo, and Searsmont. I'm here to introduce LD 872, an act concerning motor vehicle emissions control tampering. For more than 50 years, motor vehicles in the United States have had emissions control systems that monitor and regulate the engine operations and exhaust gases to maintain air pollutants at strict levels. Tampering with these devices is illegal under Federal Clean Air Act and causes excess emissions of nitrogen oxides and particulate matter and other pollutants to the air we breathe. The Clean Air Act also prohibits manufacturing, selling, and offering for sale and installing aftermarket devices, which effectively defeat these controls. Motor vehicles whose emissions control devices are missing or not working are harming our public health and our environment. The United States Environmental Protection Agency has found that tampering is a widespread problem throughout the country, including here in Maine. Tampering can cause a vehicle to emit hundreds to thousands of times more pollution than it otherwise would. And recent EPA investigations show that over 20% of registered diesel pickup trucks in Maine have had their emissions controls fully removed or deleted through tampering. Nationwide, the additional air pollution from these tampered vehicles is equivalent to adding an additional 9 million trucks to our roads. Although the Clean Air Act prohibits tampering, resource constraints have limited the EPA's ability to ensure compliance with these important environmental standards. At the state level, although the Department of Environmental Protection can enforce anti-tampering regulations for new motor vehicles, it certainly lacks the authority to address tampering on used motor vehicles. This bill before you would address this oversight and help reduce a wide range of emissions that contribute to a variety of public health problems, environmental impacts, and public nuisances. The department will follow with a more extensive explanation of the statutory changes. And before you launch your verbal darts at me, Jeff Crawford will be coming to explain more. This is the DEP bill. That's it.
Thank you, Representative Ziegler. Does the committee have any questions for Representative Ziegler? Not seeing any. We'll go ahead and bring Jeff Crawford in from the DEP. Thank you, Representative Ziegler.
You're so welcome.
Welcome, Mr. Crawford.
Good afternoon. Senator Brenner, Representative Tucker, members of the Joint Standing Committee on Environment and Natural Resources. I'm Jeff Crawford. I'm the Director of the Bureau of Air Quality at the Department of Environmental Protection, speaking in support of LD 872. To protect the environment and public health, automobile manufacturers are required to reduce pollution from vehicles by installing state-of-the-art emissions control technology. Despite these clean air requirements, some unscrupulous auto dealers, auctioneers, repair shops, and yes, individuals tamper with vehicles by altering or removing the emission control systems or installing software that can disrupt their operation. Tampering with the vehicle's emission control system is illegal under the Federal Clean Air Act and causes excess emissions of nitrogen oxides, particulate matter, and other pollutants to the air we breathe. The Clean Air Act also prohibits manufacturing, selling, offering for sale, and installing aftermarket devices which effectively defeat these emission controls. Tampering can take two basic forms. The first one is simply removing hardware, filters, and catalysts in the original emission control system. This hardware may be located in the engine, for example, an exhaust gas recirculation or EGR valve, or in the exhaust system, for example, a diesel particulate filter, or more commonly, the catalytic converter. The other one is replacing or altering the software or calibrations that control engine operations, sometimes referred to as tuning. Tuning may increase engine emissions, allow a vehicle or engine to operate without emission controls, or prevent the onboard diagnostic system from recognizing that the vehicle or engine is not functioning as designed and certified by the manufacturer. The public health and environmental impacts of tampering are significant. Looking at diesel pickup trucks alone, the United States Environmental Protection Agency estimates nationwide the emission controls have been removed from more than 550,000 pickup trucks in the last decade. As a result of this tampering, more than 570,000 tons of excess oxides of nitrogen and 5,000 tons of particulate matter will be emitted by these tampered trucks over the lifetimes of the vehicles. These tampered trucks constitute approximately 15% of the national population of diesel trucks that were originally certified with emission controls. But due to their severe excess emissions, they have an air quality impact equivalent to adding more than 9 million additional diesel pickup trucks to our road. Even worse, a full delete of the emissions controls on a modern heavy-duty diesel pickup truck can cause it to emit as much harmful pollution as 300 trucks with fully functioning emission controls. The United States Environmental Protection Agency recently issued a report, and we entered this report into the hearing record, on the estimated air quality impact from tampering with emission control systems on diesel pickup trucks with a gross vehicle weight rating of 8,500 to 14,000 pounds gross vehicle rating, for which tampering and aftermarket defeat devices appear to be especially common. EPA estimated that approximately 15% of the national population of diesel pickup trucks have no emission controls. Based on EPA enforcement cases where detailed invoice sales were available, they estimate there are 2,794 deleted diesel pickup trucks, model year 2003 and newer in Maine, which is the fourth highest in the country at nearly 21%. California and New Jersey, both with robust anti-tampering programs, have the lowest rate. Why is this bill necessary? Although the department has the authority to address emissions tampering on new motor vehicles under its Chapter 127 New Motor Vehicle Emission Standards rule, it currently lacks jurisdiction over used vehicles. This bill will prohibit businesses from tampering with the vehicle's emission control system or installing defeat devices for profit, as well as prohibit dealers from selling tampered vehicles. In closing, the proposal before you will provide the department with the tools necessary to address an increasingly common problem and help reduce the environmental, public health, and nuisance impacts of motor vehicle tampering. Thank you for the opportunity for us to provide your comments to you, and I will be happy to answer your questions.
Thank you, Mr. Crawford. Representative Hanley.
Thank you, Madam Chair. Thank you, Mr. Crawford.
Thank you.
Questions. Isn't it now against the law? Well, I guess in order to get an inspection in the state of Maine, the environmental equipment on the vehicle is part of that inspection process. So isn't that already a method of controlling this type of behavior?
It's true that some of the emission control system is in fact inspected. I believe Title 29A, which oversees the motor vehicle laws, requires inspection of a catalytic converter and the exhaust system. Unfortunately, the catalytic converter check, I believe, is just simply, is there one on the vehicle? And the exhaust system, as we know, is essentially tailpipes and associated equipment. So it's not comprehensive. It covers part of it. It just doesn't cover everything.
I'll follow up if I may.
Sure.
Yeah, well, now I noticed in here it says that a line for penalties, but it didn't say what the penalties are. Do you know what those penalties are for someone that tampers with a vehicle?
At the federal level, I don't. I would have to get back to you on what EPA's penalties have been for cases in which they have undertaken. At state level, with respect to vehicles under the Chapter 127 New Motor Vehicle Emission Standards, we haven't had many cases in the past where non-compliant vehicles were sold. Typically, the fine was either $500. More often, we worked with a dealer to buy back the non-compliant vehicle and then give the customer a new vehicle that was in fact compliant.
Whoops, Representative Hanley, you're on mute. You have a follow-up?
Yes, I'm sorry. I don't know why that didn't work, but yes, I do have a follow-up. On line 31 on page 1, it has the penalty portion, and it has a section that it references. So it looks like we already have a penalty that can be imposed. And as another question also, we're not talking about just dealers. This would affect any backyard mechanic, is that right? They would fall into all these same laws?
The proposal before you would affect individuals or persons doing work for compensation. So if they're getting paid to do the work, it would affect them.
Okay, my reading of the bill, it just looked like any individual. It didn't mention whether they were getting paid or not. Maybe I did. Maybe I got to read it more careful.
Yes, it's directed toward persons performing that work for compensation.
Thank you very much.
You're welcome.
Are there any other questions for Mr. Crawford? Thank you for joining us this afternoon, Mr. Crawford. It's good to see you.
Thank you.
All right, and I only see 2 folks left in the attendee space, both of which are here to testify in opposition to the legislation. How about we bring Mr. Garrity in first? And then we'll bring in Mr. Binder.
Am I on now, Senator?
Yes, Mr. Garrity, it's nice to see you over here in ENR. Normally,
I know. I'm more used to seeing you in another role.
Yeah, you're more of an HCIFS kind of guy, right?
Well, let's put it this way. I enjoy that committee, but no one will ever say I don't enjoy ENR as well.
Well, we're glad to have you this afternoon.
Thank you. Senator Brenner, Representative Tucker, and members of the committee, my name is Bruce Garrity, and I'm here today on behalf of several clients, a couple of whom I think won't be a significant problem. I'm here on behalf of Insurance Auto Auctions and the American Property Casualty Insurance Association, and also on behalf of the Maine Automobile Dealers Association. Let me start, if I might, with the insurance auction and APCIA. Insurance auctions are regulated as auto salvage pools under Title 29A. As such, basically what they do is take vehicles that have been totaled from the insurance industry. The insurance industry has paid whomever was in the accident the value of the vehicle, is declared a total, and the insurance agency is entitled to it. And what the insurance agents, the insurance companies then do is have these insurance auctions handle the vehicles. Now, some may be sold as scrap metal. Some there may be parts involved. They are not repairable. The very nature of being a total is that the damage to the vehicle is more significant than the value itself. And these are one way that the insurance industry helps keep costs down for insureds in Maine. And as Eric Chapa has said, and I think Senator Brenner has heard me say, we enjoy what's called a triumvirate here in Maine. We have among the very lowest rates, the highest minimum limits, and the highest uninsured population. So we're in a very good position in terms of our auto market. This legislation is not aimed at salvage auctions. Clearly, you're looking at vehicles that essentially are going to be transferred and sold. So we would urge the committee to consider an amendment that exempts salvage pools, from the statute. I have had an opportunity to confer with the department, and the department has no objection to that amendment. And I did submit testimony that has proposed language for your consideration. So I think if the committee is amenable, that it's an objection, but it's an objection to the way it's drafted now. The Maine Automobile Dealers Association has different concerns. The Maine Automobile Dealers Association is the association of new car and truck dealers here in the state of Maine. All the new car and truck dealers are members of the association. There are no members who've chosen not to be. And we have concerns with Section 2 of the bill and Section 3 of the bill. Section 3, because I can deal with it rather quickly, penalties that can include Class C crimes, I think, are a bit severe here. And anytime there is a penalty that can be considered criminal in nature, that can impact a dealer's franchise. Franchise agreements with manufacturers uniformly say that one of the things we can drop you as a franchisee for is if you've been convicted of crimes. And for the most part, I think it's fair to say they're concerned with felonies. At the same time, there's no specific language in many franchise agreements that say felonies only. So we're very concerned about the penalties provision. Second, we're concerned with Section 2A because it references for compensation in lines 24 and 25. I understand, and I have had an opportunity to talk to the department, and I appreciate the clarity with which they explain their views, but our view is that nobody should be allowed to tamper with the system, not just anyone who's doing it for compensation. So we're concerned with that limitation. We're also concerned in that we're regulated right now. New car and truck dealers are regulated under the Clean Air Act, the Federal Clean Air Act. We can't tamper with an emission system anyway. So as far as we're concerned, we're already regulated independently and have been for some time by the federal government. With respect to subsection 2B, we have several concerns. First, subsection 2B doesn't apply to the people who really create the problem, who are individuals or possibly those who are repair facilities, but who do not have a dealer's license. There's a very specific series of steps one has to go through to become a dealer that repair facilities do not have to go through. And we think that is where the problem lies. The problem is going to be with those who do the tampering. And I think it's very fair to say there's no record or history of new car dealerships or truck dealerships engaging in the tampering aspect. And that's, it seems to me, where the heart of the bill is aimed. We're also concerned because of the different ways that we get vehicles. Dealers get vehicles, used vehicles, many times through auctions. The way an auction works, there are a series of vehicles that run through a line. Literally, it's a line of vehicles, one up, next up, next up. And what happens is dealers look at these vehicles, they decide which ones they might be interested in, and they make bids on the spot. They don't have an opportunity to examine something like the emissions system. This is going to, if they're forced into that step, it's going to create real problems for the auction system, which we think, again, doesn't involve dealers being the ones who are engaged in any kind of tampering. An additional problem we have relates to sales. Many sales are performed over the weekend, and the deal between the consumer and the dealer is struck, the trade-in occurs, the new vehicle is purchased. Many times, if not most of the time, the customer walks, in fact, I would say most of the time, the customer walks out the door with the vehicle that Saturday. Dealers can't be open on Sunday, so we're basically talking about Friday nights and Saturday. Well, mechanics aren't on duty. They couldn't inspect a vehicle if they wanted to determine whether it had a problem with the emission system. There is a law that deals with transactions over a weekend called spot deliveries. And that's something that's regulated primarily by Will London, his office. It deals with vehicles that are financed, but it also deals with transactions which, once consummated over a weekend, if the dealer gets information after the fact that relates to financing, or we feel in relation to something like this emission system issue, the dealer can't change the deal. The dealer can't go to the customer and say, wait a minute, we didn't know about this. And we're concerned the spot delivery concept could apply to these kinds of transactions. There is another practical concern in the real world. Consumers, when they come in to trade in their car, they have an expectation. They do their research as to how much that vehicle might be worth, and they expect to be treated fairly when they trade in their car and get a new one. Many times there's enough equity or a significant amount of equity in the trade-in that makes the new vehicle affordable to the consumer. We're going to have a significant problem, and I think there would be a significant hue and outcry if we had to inspect each vehicle for its emission system, independent of checking to see whether it passes inspection. That's something a skilled mechanic can do very quickly. It's not as easy to inspect an emission system in its entirety, especially if you're, let's say, a junior technician who's not as skilled at spotting the welds and the various aspects of how these systems are put together. So that creates two problems. It slows down the transaction process, which I think is a lesser problem, but an important one. But more importantly, I think it's going to create difficulties for consumers who believe they have a certain value in their vehicle and then they find they don't. Pardon me. We also submitted written testimony, which I didn't want to quote from, but I believe that you have that from Mr. Brown, who's the executive director of the president of the association. So for those reasons, we are opposed for the Auto Dealers Association to its application to new car dealers under subsection 2B. And Senator, I'd be happy to try and answer any questions the committee might have.
Wonderful. Thank you, Mr. Garrity. Any questions from the committee? Senator Bennett.
Thank you, Madam Chair.
Senator, how are you?
I'm well, Mr. Garrity, good to see you. I'm just curious, maybe you don't know the answer, but if you do, I'd be curious. Are you aware if the clients that you represent were consulted with the Department of Environmental Protection prior to this bill being drafted?
I did explain our concerns with Mr. Crawford before the hearing. I also conferred with him with respect to the amendment that we proposed for the for salvage pools. And he was amenable to the salvage pool amendment. We didn't really discuss any possible amendments so far as the Auto Dealers Association was concerned, but yes, I made him aware of our concerns.
Well, my question was specific to prior to drafting, before the legislation became available.
No, we did not talk. We didn't have a chance to talk to him. I did have a brief discussion back along with Representative Ziegler, and he referred me to the department. So after that, my discussions were with the department.
Yeah, I know this is a department bill, and that makes sense. I was just curious because some of your issues with the bill seem to be, just some things that should have been flagged in the construction of the bill itself, and maybe there were decisions made not to involve the people affected. But I think that's kind of unfortunate for the department to do that. Thank you.
Sure, and let me just say we're happy to continue to meet with Mr. Crawford on this specific, the specific concerns that we have raised, apart from the concerns that were raised by my other clients.
Thank you.
Any additional questions for Mr. Garrity? All right, thank you for joining us this afternoon.
Thank you.
And last up is Mark Binder. Mr. Binder.
Good afternoon. Thank you for the time, Senator Brenner, Representative Tucker, and the members of the committee. I want to echo similarly to what Mr. Garrity was discussing. I'm with Copart, and we are a competitor of one of his clients, Insurance Auto Auctions. We are Copart. We're an international vehicle auction company with a location in Lyman, and we actually service the entire state of Maine, and we're proud to be a business participant in the state. We're a very high volume disposal company, and what's unique about us is we do not own the vehicles that we sell. We are a 100% interbased company, so all the vehicles that we sell are not owned by us. They're either owned by insurance companies, dealers, individuals, or other types of businesses that want to sell their units. We understand at Copart understand the concerns for this bill. We're required to oppose it as of now, but we've been in communication with the DEP in the last week once we discovered this bill was introduced, and we've had some very good conversations with them about the unintended consequences. A few of those are, like was mentioned previously, why are these applying to vehicles sold on salvage titles or going to be junked out? Because it's something that we think could possibly be excluded. The DP has been a really good partner with us, and they're willing to work with us from what our conversations are, and we believe the progress has been made. We've attached in our written testimony and a proposed amendment that we would like considered by the committee as well, once the DEP supports it. We would appreciate the support of this amendment, and if our concerns are addressed, we would go neutral moving forward. So I would be brief. I also have submitted written testimony with more detail, but I really appreciate your time, and I'm available for any questions that you may have.
Thank you so much, Mr. Binder. Any questions from the committee? All right. Thanks for joining us.
All right, thank you.
Okay, I believe that's everybody in the attendee space who is here to testify. So I am going to conclude the public hearing for LD 802. Oh no, wait a minute, LD 872. And I believe that brings us to the end of our day. Anything anybody needs for the work session for any of the bills that we had public hearings on today that they haven't mentioned yet? Yes, Representative Hanley.
I'm sorry. Yes, thank you. I'm wondering if it's possible to get the estimate of the number of vehicles in Maine. You know, they did nationwide counts. I'm wondering if you get the number of vehicles in Maine, diesel trucks that are estimated to have been modified.
Okay. I'm hoping Mr. Tarnikoff received that memo, and hopefully someone in the, Jeff Crawford's still here. Perhaps he'll be able to provide that for us for the work session. Yes, Senator Bennett.
Thank you, Madam Chair. Yeah, I'd be very curious as to see any sort of how other states might be dealing with this issue of that we just dealt with, this 872 bill, if there's any research we can have on that. Thank you.
Okay, so tampering in other states. Anything else? We can always send it off to Dan, I believe, in the interim if something comes up that you find you need. And with that, I believe we could take a motion to adjourn unless anyone has any other announcements or housekeeping items.
So moved.
I'll second it.
All right. Thank you, everyone, for a fantastic April start. Take care.